Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your late host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And my humblest apologies for being late. I was watching TV with Lady Rackets, and right before we just started the last episode, I looked at the time and I was like, oh, yeah, we have time. We have time to do that. Turns out we were short by about 2 minutes. So then I had to run downstairs and get everything set up. So I hadn't figured that in. Look, I only tried so hard on the math. So my apologies on that one. Let's see. Here we go. So we've got some things to talk about today. I've gotten the decision from the Michigan Court of Appeals on Lucas Gerhard. So we're going to take a look at that. And then I've got other topics to talk about as well. One of them being, whatchamacallit, Preston Poulter. Preston Poulter has fired his attorney. This happened either early this week or late last week, I believe. And so we're going to talk a little bit about that. So that's fun. Karn says, I saw a bunch of trolls on the Chauvin case comments earlier. Looks like you enjoyed dealing with them. Yeah, I did. I was gonna maybe address it. I don't know, man. It's such a boring sort of thing, but you know, we've got so let's out with this. Yes, I am still an actively practicing lawyer. No, I don't really enjoy actively practicing law that much. I tend to only do it right now when, one, I have time, which is very rare, and two, that I have, some reason to do it. And I basically practice pro bono, which means I've had to get better at saying no to people who want legal help. Unfortunately for me, it was something I was never that good at, even when people couldn't pay. So now I'm learning to say no a little more often, but I still do have active cases and I still do non-litigation legal work as well. I would rather be here, and I'll tell you why. It's a lot more fun to do YouTube. That's it. It's a lot of fun to do YouTube. It's a lot of fun to come on here, to hang out with people, talk to them, tell jokes, and enjoy myself, and then get paid for that, rather than work really hard doing legal work and then not getting paid for it. That's not the most fun thing in the world. So I prefer to be here. I like to, but I still maintain an active practice. I maintain my license, and man, is it going to be fun when I start doing CLEs with the with the locals community, because I've got a lot of CLEs to do by my submission date this year. So that's going to be a fun new endeavor sometime soon. But yeah, so people ask if I practice law, and I tell them the same thing every time. A little, but I don't want to. Not that much. I'd rather do this and not have the timelines and deadlines and obligations of the legal practice and all that stuff. And so apparently, even though I say this with relative frequency, I'm somehow lying about being an attorney who runs a small law firm in central Minnesota, which is weird because last I checked, I maintain the business entity and have to have business insurance, and I have to do all the stuff. Oh yeah, CLE. Sorry, CLEs are continuing legal education, and what it is, it's like committing suicide and not dying from it. That's what continuing legal education is. You have to go to basically a class. They're 1 to several hours long, and listen to some subject that the government is basically the Bar Association or the Ethics Division is basically requiring you to listen to. And you do that, and then you get credit. And then you have to do so many of them every couple years. In Minnesota, it's 45 hours every 3 years, or it obviously averages out to 15 hours a year. It's not a huge burden. It's just annoying. And, it's weird because you're basically doing, for a regular practitioner, right? Like, let's say you're a DUI lawyer. If you're a DUI lawyer, you're probably keeping up on DUI law. Like, if there's major appeals court or Supreme Court decisions that change how DUI law works, if there's new statutes or whatever, you're probably keeping up on that. Continuing legal education has you taking continuing education from areas where you don't always practice, including in Minnesota, some anti-bias training and some ethics training. So anti-bias, you can guess what that ends up being, and ethics training tends to run along the same line. That being said, those are the required hours. The others are pretty flexible, but you end up taking courses on legal areas where you don't really practice. Now, for me, it doesn't matter as much because even when I was more actively practicing, I practice in a broad scope because small town lawyer, you do kind of what's around. And so but in concept in general, it's a little bit of a mess. There's someone who's doing work comp all day. They really don't need to know about criminal procedure, for example. It's just not that important for their practice. So I don't really like it, but whatever. And you have to pay for it, and it's not cheap. So there is that too. It's like, it's like $150 an hour or something. Depending on how you get it. There's ways to get free ones, and there's promos and all that, like any other product. But the going rate on it, just to pay for continuing legal education, is, it's over $100 an hour for the stuff. Lots of fun. So that being said, yes, the other thing I was addressing. The other thing, sounds like you're getting grifted. Yep, and I'm legally required to be grifted. So the other thing I was addressing in the chats is apparently I am just a commentator, and I use my law firm as a disguise to provide opinions that are favorable to the alt-right, which is weird. Because whenever that gets brought up, I always think about it. I am not a good alt-writer. I'm really, really bad at it. And I have to imagine, actually, like, alt-right people make fun of me all the time. They don't like my opinions very often because, well, I try to tell people the truth. And there are people that, like, on some issues, they have a difference of opinion between what the law is and what the law should be. And that's fine. Lots of people do. But, I try to tell people, and I try to make that distinction too. Here's what the law is versus here's what I think it should be. But what I think the law should be usually disagrees with the alt-right, though. So that's kind of weird. Like when I was arguing with all of them about porn and stuff, but it doesn't really, like, you know, it is what it is. It is what it is. People get really, really salty over all sorts of stuff. I don't know. I'm just too gay to be alt-right. But anyway, that's just the occasional time. Oh, and for the last time, I don't delete comments. I don't delete comments in the comment section of videos. I want your weird opinions. I want your crazy stuff. I want you to come tell me about how much fentanyl George Floyd took, how much fentanyl George Floyd has taken. I want your internet graph of the fentanyl per kilogram acceptable limits with inherent variance clouds on either side. I want all that. I love that stuff in the comments. Put it all there. I would never delete a comment. There is no benefit to me ever to delete a YouTube comment. There's none. Criticisms, like critical comments, good. They're great. Happy comments, great. Comments that mean nothing, great. Irrelevant comments, all of its engagement. It all benefits me. It all helps YouTube say, this channel has activity. Now, YouTube deletes comments all the time. They don't like what people have to say. I thought people knew this, but apparently they think it's me. But I'm incentivized to never moderate comments. I have no reason to. So, I just want to point out that no, I don't. I will never delete your comment. I probably didn't see it in the first place. That's the first part. If it's nested in a thread with other comments, I almost definitely didn't see it. But I probably didn't see it. That's the reality. There are hundreds of comments that come on every video, and I don't have time to follow up on them. But no, if your comment doesn't show up, it's YouTube. Rewrite it. Write 10. I don't know. Write 500 comments by yourself. Knock yourself out. Every comment section should be your go-to discussion forum on the topic. Believe me, nothing on earth could make me happier than you coming back to a video to write more comments because you're arguing with someone else. Believe it or not, like when you write your comment, you're like, haha, send, and then you go do something else, and then you get a notification that someone responded, and you come back and you click on the video again to write another comment. That's an ad. That's an ad. I'm happy. Watch another one. Hit refresh. Keep coming back and talking. It only makes good sense for me. More views is more stuff. More views helps. So I would, again, it doesn't make sense for me to disengage people from commenting. You can't make fun of me in a way that I would actually be offended enough to delete the comment. Yes, that is a challenge. And if I think that what you said is stupid, believe me, I'll just tell you. I'll say you're a moron. I'll say you're an idiot. I'll say that's stupid. I'll say please don't eat soup without a helmet. Whatever it is, I'm going to call you dumb. Rather than delete your comment, guess what? If I type in URDUM, right? You might come back and say, no, am not. And then that's a view. This is business, y'all. There's no secret here. This is Grifty McGrifterson. If I can grift you into arguing with me and every comment is a view, you bet your ass I'm going to do it. So, that being said, just for everybody's idea, just for everybody's edification or whatever it is, I don't want to delete your comments. That takes it's way more time and way less fun to delete a comment than to say, no, you. No You is faster. I don't have to like go all over the place and like hit the 3 dots and find delete comment or whatever it is. I don't even know if that's what it says, in all honesty. It's way faster to say no you or you're dumb. So that being said, I have to address something. Someone out there has cut me deep. What is Attorney Tom saying now? Oh no, he's setting up the class action. My days are numbered. Someone out there has cut me deep, and that is Joshua Kerner Moon. He watched the Vic interview, and he said that if he were Vic, he would do things a little bit differently. Actually, what he said was completely differently. This is very rude criticism of the legal strategy. And it's also, I'm going to show you why I'm the lawyer and he's the Serbian expat or whatever who can't even go into a Walmart in the United States without being murdered by a UK guy named Vordak. This is why. His suggestion for Vic was to say, I couldn't possibly have done anything because I'm a gay man. Because he said that Vic, I didn't say this. He said that Vic looks a little gay, talks a little gay, and wears gay pants. So he said he should use the I live my life as a gay man defense, therefore none of this could have happened. The problem is, and this is what short-sighted McSerbian is not getting, is that that's only half of that defense. The Kevin Spacey defense has been tried. And the only way that the Kevin Spacey defense works is if you subsequently kill all of your accusers. That's what you have to do. You can't just become a gay man. You have to become a gay man whose accusers all die of natural Kevin Spacey related causes. That's how you have to do it. So I'm sorry, Janny Jersh, you missed half of the legal strategy there. You can't do it without the killing. And, some people aren't willing to kill off everybody. So I'm not saying it wasn't that's a joke. That is a joke. Jesus. I've got to clarify things. People are way too spurgy right now. So I got to clarify that's a joke. Come on now. Nick Ricada said that Vic Mignogna suggested the Kevin Spacey defense and it was discussed. I'm going to start telling people to go find McAfee and Epstein. Okay. All right. I've got this bourbon that I've never tried before. It's Smooth Ambler Contradiction Bourbon, 92 proof. It's got an elephant on a bourbon barrel. I'm going to try it out. Josh is moving back to the US. Is he coming back as a woman? It's the only way I can think he'll be safe. H3 versus Crowder, thoughts? You know what? If you're invited to a debate, this is my personal opinion. If you're invited to the debate, show up and do the debate or don't do the debate. Bringing someone else to debate for you isn't like that's not a epic troll to me. That's just lame. But I also think debates are lame. So when people ask me to debate, I usually say no. I would prefer not because I don't like debating. I like discussing things. I really do. But debates are full of like gotchas and dishonest communication for the purpose of advancing your point rather than for getting to answers. I don't like to do them. And the couple that I've done, when people asked me, I said, I don't really want to do it. For that reason, I don't like debating. And you can, I don't know where you can see my last debate. It was with, I had a debate on this channel. Well, I had a debate with Shane, I guess, but that was just, that you can't call a public execution a debate. I had a debate with a guy called the Critical Retort or Critical Riposte, I think, on this channel. It was about, I think it was about like atheism or something. I don't know. And I didn't really want to do that one, but I did a debate about COVID on the Kill stream early on in the lockdown with a guy with Red Elephants, the guy from Red Elephants. And that was fine, except it was pointless. And there was a bunch of like random character attacks and snarky remarks that was someone trying to win the audience of the debate without actually discussing the issues. But I stand by everything I said in that debate, and I think I was shown to be mostly correct. The one thing I wasn't correct on is I thought a lot less people were going to die from COVID. Although, depending on how you look at the numbers, maybe I wasn't incorrect. Was Nick pro lockdown? No. It was 100%. 100% opposed to the lockdown. That was the weird debate position. Andy Beshear, the governor of Kentucky, had just locked up people who were suspected of having COVID, but there was no actual evidence that they had been tested. He's posted police officers outside their house to lock them in. And I said, that seems like a government overreach to me. I'm not really okay with that. The other guy said, no, I want the police to lock him in the house. And I was like, what do they do if they try to come out? Shoot him? Yes. Okay, that's a bit far for me. I'm not a fan of the police enforcing a quarantine on an individual at their home at gunpoint. Just not my thing. Never have been for that. And apparently, according to some people, that was the cuck position. Believe it or not, being the statist bootlick with their tongue all the way up the anus of the state for COVID was the cuck position of the far alt-right back then. That was the correct position of the farther right or something. Again, that's just how it was early on for a lot of people. They were really, really scared of the virus on the right. I don't know if they want people to remember that now or forget that. I don't know how that works out, but there were a lot of people who were like, no, we want the government to lock us all down. That'll be great. I was like, weird. That's a bit much for me. But hey, you do you. That's why I don't like debates, though. Because, at the end of the day, if that's what you want to do, I don't care. It doesn't affect me. You can't lock me in my house. You can't do that. But if you want to advocate locking other people up in their houses, I guess knock yourself out. So there you go. I don't know. How did we get on the topic of debates? That's weird. I feel like I accidentally pushed myself into it, but I didn't mean to. That's what you tell all the ladies. You won the hearts of millions, Nick. It's okay. H3 and Crowder. Thank you. Yes, that's how we got there. So, Crowder, look, Crowder wants to do debates because debates make Crowder a ton of money. Good job. Love it. Do it. I like Crowder. I have no problem with him. I love what he does. I don't really like debates. I don't think Crowder's that great at debating. He did a gun debate once. This is years ago. He did a gun. I think he may have even apologized for this, if I'm not mistaken. But I listened to a gun debate he did one time, and I'm on Crowder's side on guns. But he treated the other guy, the other debater, really, really poorly on his own show. On Crowder's show, he brought a guest on to debate him and treated him, in my opinion, he treated him a little rudely. And I think he ended up apologizing for that later because I think he realized that he was being what they in the UK might call a cunny on that show. But again, more power to him. Debate all day. Make all of the money in the world. I like Steven Crowder. I've got no problems with him. I think he's not the best debater on earth, but that doesn't really matter. It's why I don't really like debates. Okay. Let's get to some of these early chats. We've got Linda Marie says, did debate in high school, and at a regional competition, someone sold Master Debater t-shirts. They sold out because we were all immature. Good. That's what debates are actually for. That's what they're actually for. Richard Grubber says, both my brothers and my teams won the sports balls tonight, and it's flat F Friday. Take some money, you absolute lad. We are going to win, boys. I like this guy. Richard Grubber, man, he's got positive energy every stream. We're going to win. I'm not sure what, but we are. Alex Ghost says, catch you on the replay if I don't catch your stream. Just wanted to clarify what I meant. The Deface Floyd statue reminded me of you. It's because it's a white statue and they put black paint on his face. Oh, no. Why would they do this? Phoenix Oram says, hey, Nick, I listened to Sword and Scale Plus cover the Ricori school shooting from 2003. Can you explain how Manhattan rule works when pleading insanity by mental defect? Godspeed. No, I have no idea what any of that means. I could read up on it and do research and find out. But no, I off the top of my head, nope. Sorry, brother. I do not know. Fenrir Lycos says, is Pump and Munch still safe after the sentencing? Hope it has life insurance. Look, it's a building. It has life insurance. Our people don't have life insurance. Our buildings got life insurance, but our people don't. I went on the Kill. Yeah, I did do a porn debate on the Kill stream too, and took the side that porn is art and protected as free speech. The reason I did that is very simple, because according to the Supreme Court, porn is art and protected as free speech, and has been since the 60s. So, and I'm pro speech generally speaking. So yeah, you're right. I did that. I forgot about that one. Which day of Anime Matsuri is your panel? I don't know yet. But I will, as soon as I do know, I'll let you know. How's that? Generalissimo says, here in Virginia, Loudoun County making headlines fighting critical race theory. Dude, it is the, I want to call it Loudoun County, but it's Loudoun County. It is the epicenter of critical race chicanery John McCainery. Parents are hugely against. The board ridicules them. Former senator spoke. Board cut his mic. Parents boo. Board calls the police as if we serve government, not vice versa. Commies. Dude, I saw that. I saw the one guy get arrested. And they're like, this is an illegal gathering. They're like, it's not illegal. It's a school board meeting that they call. They're like, it's an illegal gathering now. Oh, okay. Attorney Tom. Yeah, I'm hosting a panel at Anime Matsuri. Let me see what exactly. I don't remember. Let me read exactly the format of the panel because I forgot what it was. Hold on. Can I? Thank you, phone. I can't wait. It's almost new phone time. Let's see what the panel is. The panel will be called The Awakening. How the Culture War is Crippling Entertainment. There you go. The Culture War is Crippling Entertainment. And it's probably not entirely what you think. It's gonna be critical of both sides of the culture war, and as far as entertainment goes. So yeah. Nick is going to wing it. How did you know? Niku Yasha says, hey, Nick, just introduced a friend of mine to Demolition Man. Yes. My next quest is the Lethal Weapon movies since he hasn't seen them. Oh, my gosh. What's wrong with your friend? Are they okay? Did they travel through time to be here? Like, how did they miss those? Will the panel be streamed online? Unsure. Not by me. Matsuri may be streaming it. Don't know. Fan Advocacy Network says, Nick, I have a legal question. I was recently violated by a surprise Legal Eagle short video showing how aroused he was about the woman who filmed the George Floyd sidewalk video getting a Pulitzer. Can I sue for damage? Damages. Wait, what? Is that a thing that Legal Eagle just did? Isn't that girl 17? She might be 18 now. She got the Pulitzer. Why? Oh, her hard-hitting investigative work of literally fucking walking by. Oh, hey, World Star. World Star! Oh, he did. Okay. Yeah, you can sue for damages. Tina says, are all comments really fine? Like my comments are to tell you that you should wash your models with warm soapy water before you paint them. Not true. You should wash your models with something oil-based, if you know what I mean. And did you know Kentaro Miura died? I did not. I don't even know who Kentaro Miura is. Nivok the Orc says, did you have a chance to get any of the LE Games Workshop books released on the 12th? Sabbath Worlds Crusade Special Edition is beyond gorgeous. Vindicator Insurgency is fancy as heck. Also, Steam Summer Sale, time to spend. I have a man on the inside. One of you wonderful members of the chat procures the books from a local shop for me because I'm never able to get them. And yes, I have gotten all of them. I got the Sabbath Worlds and Vindicator Insurgency or whatever. I got Gazgul, Prophet of the Wa as well. And I got the Sisters of Battle limited edition box set that came out. They kind of snuck that one out. And I also got Godblight, which They stupidly limited to 750 copies like a bunch of jerks, and it sold out immediately. A-Wig. Comments telling me how to fix my computer. No, they're not okay. But they won't be banned. I'll just scream at you. All right. I've got the Lucas Gerhard appeal decision. I want to briefly talk about the Vic interview. Just some thoughts on it. And you debated Beardson, not red elephants. He kept talking about your nose length. Was it Beardson? I thought it was a guy from Red Elephants. I don't know. You need to lock the frames at 60. The frames are locked at 60. But Gelf, what? You're going to go play in traffic? He says, have a drink for my dog. She got killed 30 minutes ago. Oh, God, Gelf. What the hell? It was probably like 40 minutes ago now since when you sent that. But, dude, I am sorry to hear that. Why? Sorry to hear that, brother. All right. Yeah. Here we go. To Gelt's dog. Sucks losing a pet and a friend, man. Sorry to hear that. Really am. Okay. How do we go about this? The first things first about the Vic interview. I'm leaving it up on the channel. I will not be moving it to the archive channel. I may upload it to the archive channel just for completeness over there, but I won't be moving it over there. Same with the Chauvin sentencing hearing. You know, both of those are kind of like fully in theme of the channel. And so I'm leaving them up over here. I don't do that very often, but the Chauvin thing, I have a Chauvin playlist, so I put the sentencing in there as well. And I'll probably, I don't know when I'm going to have time tomorrow, but I want to do a post-mortem on the Chauvin sentencing and kind of get the sentencing memo and break down what Cahill's reasoning was and kind of look at it. Because, I mean, all I heard was whatever was at the hearing today, which wasn't very much. So, but the long and short of that is there were 4 aggravating factors. He could have easily doubled or more of the sentence. Instead, he decided to add, 10 years or whatever, which, I guess good for Chauvin. That comes out slightly in his favor. I mean, it's not. It's like getting punched in the stomach instead of getting punched in the nuts. I mean, you still got punched in the stomach. It's not that great, but at least your balls are okay. Do I think the sentence was fair? It's a very, very loaded question. I don't know that he should have deviated from the guidelines, but in the context of him finding 4 aggravating factors and really very few mitigating factors that I can think of would apply to Chauvin, it could have been a lot worse. So I don't know. But, he's going to try his mistrial approach. I don't know how effective that's going to be. He's got some decent arguments for it, but at the end of the day, those decent arguments are up against the reality. For Chauvin, the hardest reality on earth is that he had a video of him killing a guy for 9 minutes. And yes, I know, listen, I get the distinction, the fentanyl killed him, all of that stuff. I'm saying what the jury is watching in their mind, what they see played to them over and over is him killing a guy. That's how it's framed. That's clearly what the jury thought. That's what the jury saw. Doesn't matter how many people on the internet argue about that. That's what the jury saw. If there wasn't a video, same circumstance, but no video, he might have gotten off. He might have walked. But people don't like watching other people die. And they don't like having to spend 10 minutes doing it every time they do it. And so that really played against him. Maybe that's unfair. It's for him, it's unfortunate for sure. But we'll see. I'm not overly optimistic on his chances of getting it overturned. But Nelson will put in a good effort, I guess. Oh, excuse me. All right. But that being said, the Vic interview. The Vic interview. I thought the Vic interview went really well. We had over 5,000 live viewers. It was a lot of fun. It was a lot. It was a good interview. I thought. I hope you guys enjoyed it. I hope everybody who watched it enjoyed it. It was a very, very active chat. And we got to see a little bit of insight into Vic, which I thought was important. If I had my way, this would have happened over a year ago. But you don't always get your way. And I hope that it provides some encouragement and reinforcement for people who've been supporting Vic this whole time. That's what Linda Marie says, I didn't finish your... I don't see that rest of your chat. That didn't come through. It just says they sold out because we were all immature Lamau. Linda Marie says, F. Andy Bashir, that is a government overreach. Thank God Kentucky had Daniel Cameron to fight for us. There you go. Mediation confidentiality compromised. No, I don't think there's any confidentiality that has been breached there by Vic sharing what the offers were. There's no... they didn't use that in court in any way. There's nothing that should really have any effect on. Plus, the confidentiality of that is in the hands of Vic. That's his confidentiality to tell. Other people can't breach. Vic and the other parties each hold their own confidentiality of what went on. Each of them can divulge that information if they choose to. If someone else divulged it without their consent, that could be a problem. But yeah, I think Vic came across really well. I do think Vic lives in a little bit of a different and still an older world. And this is not a criticism as much as it is an observation. He still seems to be... He seems to be in this... I don't know how to put this. Well, one, this idea that he's like not allowed to be mad at these people for what they did to him. I think he is fully allowed to be angry. I don't think that means he wants them harmed or anything like that, but I think he's fully allowed to be angry. And I also think maybe he's heard from some people some inaccurate information about what quote unquote his side has done. But this isn't new. This isn't new. With the with Vic, I mean, he was early on, you know, when Ron demanded he call out someone for threatening, I think death threatening Monica Rial. And we found out, of course, that death threat was a fake voicemail or a fake automated robocall. It's a prank call service that you can do. When she laid out the context or contents of the voicemail, that's a prank call service. I've received the same prank call. So that's how I knew about it. Now, she didn't know that, but it's a fake thing. And so, you know, Ron demanded that Vic apologize. And Vic, you know, wrote into Twitter to immediately apologize. This is very early on in the thing. So it doesn't surprise me that much that he thinks that, like, well, when people have told him that I have somehow, like, gone after and harassed these people or encouraged other people to do the same, he might think that I do that at some level. I don't know. It was kind of interesting the way he said he disagrees with my style. Well, I mean, if my style is calling them fat and that's what he disagrees with, fine. But I got the impression it was a little more than that. I got the impression that he thinks that maybe I have somehow incentivized people to go after these people, which I have never, ever done. Ever. I've actually told people, leave them alone. Just leave them alone. Laugh at them. Mock them. And just so we're clear, me making a video on my channel is not going after them. It's not only not legally going after them, it's practically not going after them because I'm not bringing them here. I'm not sending them the videos. I'm not inviting them. I don't care if they never hear it. I'm expressing my opinions to other people. In the same way that if you went and talked to someone in a hallway or at the office about someone else and just talked about them and made fun of them or whatever, that's not going after them. Never was. And I would not advocate for that. In fact, I've advocated the opposite over and over and over again. So I think he might be sort of maybe has received some incorrect information there, but that's the nature of how these things work. But all in all, I thought the video was very good. I hope he continues to be more and more in public. I mean, he's doing appearances when he can. I really think that he would do well increasing his Twitch presence or increasing a YouTube presence or concurrently using his Twitch channel to upload clips to YouTube, to go to Twitch, whatever it is, but just getting more and more interaction and engagement with people. I think he should do that. I think that would be great. I think he has a lot of different talents and experience to offer people, and he should capitalize on that. That's my opinion. So hopefully, you know, this will lead him to the confidence that it's okay. It's okay when you're somewhat known to actually speak on your issues. The idea that you should say nothing when you are somewhat public is an antiquated sort of approach to these problems. And when you've got a Twitter brigade ripping you apart, I don't think silence is the answer anymore. That's my opinion. You can't convince me that silence is the answer. I think you need to immediately address situations. I think you need to address them full on. You need to deny your involvement or your liability or your culpability or whatever it is. And you need to energize and engage the people who support you, because whatever happens, keeping those people who support you is critical to what happens, critical to how you're able to proceed in the future. So I just wanted to that's my opinion on that. But I was very, very grateful to have him come on. It was something I've been trying to set up for a very long time. And I hope people were surprised and elated to see it. Lots of people have watched the live stream. It's up at, how many, what do we got here? It's up at like 56,000 views or something like that now. Where is it? Yeah, 56,000 views. So people are coming in to see it, which is great. And I think the more people who see that, someone in the chat a little bit ago said it right. Vic is his best defense. Vic is his best defense. And so I think him being out there is a good thing. That being said, let's get to Lucas's stuff. Let's get to Lucas's. I'm just pulling up the document here. What? Okay. Just had a weird, that was a very strange email from a Chinese company claiming that they manufacture 4 and 5G routers. Great, brother. You do you. I don't. Probably a scam anyway. Oh yeah, we'll sell you a bunch of routers. Here we go. General Isimo says, I like and critically support this show for the neutral analysis and silly rants, but lately your obsession with the futa question is just disturbing. You ask every guest, it's not healthy. Nick, we're here for you, please. Hey. Damn it, Fox Chase Racing. General Isimo, I do not ask them. You guys ask them. It's you guys who do that. By the way, did you see me try and navigate that with Vic? I'm like, someone asked him the futa question, and I'm like, okay, we don't need to deal with that. And he's like, what? I'm like, you don't want to know. He's like, well, what is it? What, Vic? You don't want to know. Not, well, what is it? Now tell me. No, I don't want to explain this to you. This is insane. Wolvenar, yeah, I did the early super chats. Fox Chase Racing says, Nick, never be afraid to say no or stop or it hurts. Look, I have several safe words. But thank you for the encouragement on that. I'll try to remember. Yeah, I'll do a quick rundown on who Lucas is. Lucas Gerhard. He is a young man. He's in college on the northern peninsula of Michigan. He was northern peninsula of Michigan. His college allows guns at the campus, and you just have to check them into the campus armory. He posted a picture to Snapchat, to his Snapchat stories. Someone who was not the intended recipient of the Snapchat saw it. The picture was a picture of his AR-15. Says, taking this bad boy up to school, gonna watch the snowflakes melt. And by snowflakes, I mean snow. Winky face. He is charged with making a terroristic threat of violence because of that picture and the accompanying message. He has been held, he was held in jail for 82 days without trial, then without a hearing. Then he was moved from jail to house arrest. He was moved from jail to house arrest and has been on house arrest since November of 2019. So now he is still on house arrest for over a year and a half. So now we've got they moved to dismiss his case. They moved to quash this charge of making a threat of terrorism, and that was denied. They appealed the denial of the move to quash the threat of terrorism, and the appeals court has shockingly rejected the appeal. They have said that the decision of the lower court is affirmed and it is going to go to trial. That someone had an agenda against him before seeing the image, it is an important fact you gloss over. It's an important fact that I gloss over because the court has not recognized it in the record anywhere that I've seen. They just keep ignoring that. So even though it's in the motion paperwork, they just ignored it. So that's why I haven't been bringing it up as far as the case goes. Ryo Hoshi says, at what point can they complain of a violation to the right to having your trial in a timely manner? With COVID, no one gets to complain. No one gets to complain in COVID. Everybody's rights to speedy trials were violated. And it was just okay because the court said, nope, we have good cause. All right, so let's check out the ruling here. It's 7 pages. We'll go through it pretty quickly. In this interlocutory appeal, defendant appeals by leave granted the order denying his motion to quash the charge of making a threat of terrorism on which he was bound over from the district court. Importantly, the issue was not whether defendant actually made a threat of terrorism, which would be a question for the trier of fact. Rather, the issue is whether on these facts defendant can be charged at all. The issue before us turns on whether a social media post made by defendant can constitute a true threat. We affirm. Defendant was a student at Lake Superior State University, which has a unique policy that allows students to bring weapons onto campus if the weapons are immediately registered and stored with the Public Safety Office. On August 22nd, 2019, defendant posted an image to his story on Snapchat, a social media platform that allows users to send pictures with or without text that can be viewed by the user's registered friends for 24 hours before the image disappears. Defendant posted an image depicting an AR-15 semi-automatic rifle with an attached bayonet, along with the text saying, "Taking this bad boy up, this ought to make the snowflakes melt, and I mean snowflakes as in snow, winky face emoji." 2 LSSU students saw the post and alerted public safety. Both students expressed the belief that the word snowflakes referred to Democrats or liberals, which defendant later confirmed was accurate. And here we go with the first issue in this. This is how you get into trouble. And no one ever told Lucas, I'm guessing, not to talk to the police. But he went ahead and talked to the police. But I want to point out, this ought to make the Democrats melt or the liberals melt still isn't a threat. Still not a threat. Let's just be clear. That's not a flamethrower, and people don't tend to melt. I guess it's possible. It's a little difficult. One student felt that the post was inappropriate, although not threatening. But the second student, and this is the one who's been after Lucas for, had been after Lucas for, I think, a year at the point. The second student testified that the text made her believe that defendant intended to use the gun to shoot liberal students. Defendant reported that he took the post down after he learned that it could be interpreted as a threat. So, here you go. One, don't take it down. Don't take it down. Because if you take it down because you think it's a threat, then I guess they get to use that against you, right? By the way, they used his good-natured act against him. Someone said, hey, man, that could be taken the wrong way. He's like, oh, shoot, I better take that down. Yeah, someone said that it maybe could sound threatening, so I took it down because I didn't want it to sound that way. Click, click, handcuffs, get arrested. Are you serious? He specifically communicates that he didn't want to communicate a threat, so he took the post down. That's what gets you arrested. Don't talk to the police. Defendant arrived to campus the following day and checked in his AR-15 rifle with public safety at approximately 8 a.m. 2 police officers questioned defendant about the post in his dormitory room later that afternoon. Defendant confirmed that bringing this bad boy up referred to him bringing the AR-15 to campus, and that snowflakes referred to Democrats. However, defendant stated that by melt, he meant he wanted to make the Democrats' mind melt when they found out that he was bringing a gun to school. Defendant was arrested the following day and charged with making a threat of terrorism pursuant to Michigan criminal law. I guess that's what MCL means. 750.543M. At the preliminary examination, defense counsel argued the charges were a violation of defendant's rights under the First Amendment, that the anti-terrorism statute was vague and overbroad, and that the statute did not apply because defendant's Snapchat post was not a threat of terrorism. The district court disagreed, holding that it had been interpreted by higher courts as constitutionally valid, and the question of whether the statement constituted a true threat was a question of fact for the jury. The district court found probable cause to believe that the elements had been met, and it bound the defendant over. Defendant filed a motion to quash the charge, arguing First Amendment protected his speech, that the district court therefore abused its discretion by binding it over. The circuit court disagreed and denied defendant's motion. So here's the standard of review. Standard of review. A district court's magistrate's decision to bind over a defendant and a trial court's decision on a motion to quash an information are reviewed for an abuse of discretion. A trial court abuses its discretion by choosing an outcome that falls outside the range of reasonable and principled outcomes. A trial court necessarily abuses its discretion when it makes an error of law. Wait till we read the statute. It's coming up. Whether conduct falls within the scope of a penal statute is a question of statutory interpretation, which we reviewed de novo. Questions involving the constitutionality of a statute are also reviewed de novo. So defendant first asserts that the statute is unconstitutional. We disagree. Defendant was charged with making a threat of terrorism under the statute of the Michigan Anti-Terrorism Act. Statute says a person is guilty of making a terrorist threat or making a false report of terrorism if the person does either of the following, okay? Terrorist threat or false report of terrorism. 1, threatens to commit an act of terrorism and communicates the threat to any other person. What act of terrorism did he threaten? 2, knowingly makes a false report of an act of terrorism and communicates the false report to any other person knowing the report is false. It is not a defense to a prosecution under this section that the defendant did not have the intent or capability of committing the act of terrorism. Person who violates this section is guilty of a felony punishable by imprisonment for not more than 20 years or a fine of not more than $20,000 or both. Here's an act of terrorism according to the statute. A willful and deliberate act that is all of the following. 1, an act that would be a violent felony under the laws of this state, whether or not committed in this state. Not sure what that is. 2, an act that the person knows or has reason to know is dangerous to human life. Making the snowflakes melt. 3, an act that is intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. All of the following. So what intimidation or coercion of a civilian population or influence of a government unit was happening here? All of the following. It has to be all of those things. So what intimidation? Notwithstanding any provision in this chapter, a prosecuting agency shall not prosecute any person or seize any property for conduct presumptively protected by the First Amendment to the Constitution of the United States in a manner that violates any constitutional provision. This should prevent it, because his statement should be presumptively protected by the First Amendment, because his statement does not fall into the true threat analysis. Defendant properly recognizes that this court has already held it to be constitutional, albeit with some clarification. In People versus Ostanowski, this court explained that the legislature's use of the word threat was meant as a reference to what the United States Supreme Court has defined as true threats, which are not constitutionally protected speech. A true threat, quote, encompasses those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. So think about what the court is saying here. The court is saying that his Snapchat encompasses or is a statement where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to an individual or a group of individuals. That's what they're saying. This interpretation was further bolstered by the existence of the statute which prohibits prosecution for presumptively constitutional speech. Defendant contends that Ostanowski 1 was wrongly decided and an exercise in judicial legislation. We disagree. The First Amendment applicable to the states through the 14th Amendment provides that the government shall make no law abridging the freedom of speech. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Therefore, statutes that criminalize speech must be interpreted with the commands of the First Amendment clearly in mind. The protection afforded by the First Amendment, however, are not absolute, and we have long recognized that the government may regulate certain categories of expression consistent with the Constitution. One of those categories is true threats. Furthermore, a presumption exists that a statute is constitutionally sound, and this court will construe it as such unless it is constitutional. Unconstitutionality is clearly apparent. So they're saying that no, statutes that are assumed to comply with the Constitution unless they don't, so therefore they can read threat as true threat. He was trying to get that decision undone so that it just said threat, so then it would be unconstitutionally overbroad, was the strategy there. We decline to revisit the case. In any event, we are unpersuaded that doing so would be warranted. Our clarification that it applies only to true threats was a reasonable and supported interpretation of the existing language of the statute that rendered it consistent with the First Amendment and with the requirements, and with the statute about not prosecuting. Further, because the definition of acts of terrorism and the requirements encompass the elements identified in the definition of a true threat, our interpretation rendered it constitutionally valid. So, applicability of the First Amendment. Here we're going to get into the meat of whether or not this is a threat. Defendant next argues that the First Amendment applies to this matter. We agree in part. As discussed, the First Amendment is applicable to the states and prohibits the states from punishing speech for being offensive or disagreeable. There's no doubt the defendant's charge arises out of speech that the defendant made, so the First Amendment applies to this matter. Nevertheless, as also discussed, the First Amendment's protections are not infinite. The First Amendment permits some content-based restrictions in a handful of categories of speech, including advocacy intended and likely to incite imminent lawless action, obscenity, defamation, speech integral to criminal conduct, so-called fighting words, child pornography, fraud, true threats, and speech presenting some grave and imminent threat the government has the power to prevent, although a restriction under the last category is the most difficult to sustain. Therefore, although the First Amendment applies to this matter, its protections may not extend to the specific speech at issue. Preliminary assessment of the threat. Defendant argues that even if it's constitutional, the requirements of the First Amendment, Ostanowski, and the statute require the district court to make an initial determination as a prerequisite to prosecution that the defendant made a true threat. We agree in part. He further argues that the lower courts erred as a matter of law by concluding the defendant was properly bound over for trial. We disagree. In a preliminary examination, a district court's function is to determine whether the evidence is sufficient to cause an individual marked by discreetness and caution to have a reasonable belief that the defendant is guilty as charged. Importantly, the inquiry is not into actual guilt or innocence, and the requisite quantum of proof is far less than beyond a reasonable doubt. Rather, reasonable doubts or conflicts in the evidence must be reserved for the trier of fact. The only requirement is that there must be evidence of each element of the crime charged, or evidence from which those elements may be inferred. The prosecutor must therefore provide some evidence the defendant held a general intent to communicate a true threat. Nevertheless, it is typically a question of fact for a jury to determine whether a statement constitutes a true threat. As defendant concedes, a true threat does not turn on whether the speaker intends to carry out the threat, but on whether the speaker intends to communicate the threat. Okay, so show that they intended to communicate the threat. Defendant is correct, insofar as the district court was required to make a preliminary finding that there was some evidence that defendant intended to communicate a true threat when he made a Snapchat post. However, defendant further argues that the district court was obligated to make an initial determination as a matter of law whether his speech constituted a true threat. Defendant is incorrect. Defendant observes that when facts are found that establish a violation of a statute, the protection against conviction afforded by the First Amendment is a matter of law. However, defendant overlooks that whether his speech constituted a true threat is itself a question of fact, and if the trier of fact were to conclude that the defendant did not make a true threat, it is already established as a matter of law that he could not be guilty of making a threat of terrorism. No, that's what he wanted, yeah. Instead, defendant would put the cart before the horse and eliminate the protection of a jury evaluating whether particular speech constituted a true threat. I don't know that's I don't know that that's a proper jury question. True threat analysis is a matter of law. Although not binding on us, we find persuasive that the United States federal courts have generally agreed. The district court, in United States versus Baker, the district court held that whether speech constituted a true threat was a question for the jury unless the speech could not possibly constitute a true threat. Case closed. It can't possibly constitute a true threat. It can't. Under no circumstances does this constitute a true threat. This is consistent with the purpose of a preliminary examination to ensure that there is some evidence the speech could be a true threat. 10th Circuit explained that it is a question of law whether a reasonable jury could find a statement to be a true threat, but whether the speech actually is a true threat would generally be a question for the jury. 2nd Circuit held that whether the First Amendment applies to a statute is a question of law for the court, but unless the trial court finds as a matter of law that particular speech could not be a true threat, whether the speech is a true threat is a question generally best left to a jury. The 3rd Circuit likewise explained that the trier of fact should generally decide whether speech is a true threat, although the trial court is empowered to determine that the speech is so obviously not a threat that a charge should be dismissed as a matter of law. Several other circuits have also held that whether a particular speech constitutes a true threat is not a question of law for the court, but a question of fact for the jury. The clear conclusion is that the preliminary examination for a charge making a terroristic threat should include consideration by the district court of whether the speech at issue could not possibly be considered a true threat. However, defendant is incorrect in asserting that the district court should decide as a matter of law whether it actually is a true threat. The district court properly carried out its duty by determining that the Snapchat post could constitute a true threat. The circuit court likewise properly concluded that although defendant had several very good arguments for why a jury should find him not guilty at trial, the bindover was proper because the post could be a true threat. So I know this is thick legal language, but at the end of the day, they're saying that the statement that he wrote could be a true threat. A true threat. And a true threat encompasses the intent that he intended to communicate a violent criminal act. Which I can't, my brain cannot process this. It cannot figure out how they even get there. No reasonable person could possibly determine that he was threatening anybody with this. Defendant finally argues that the district court erred in finding probable cause to bind him over for trial, and the circuit court erred in failing to quash the charge. We disagree. We initially note that the student who reported feeling threatened by defendant's post was apparently not an intended recipient of the post. As a general matter, a person may not be punished because he or she negligently overlooked the possibility that someone else would show a person not intended as a recipient the Snapchat contents. So, however, the evidence at the preliminary examination included that defendant had shared his Snapchat post with a large group of students, many of whom did not even know each other. And the student who felt threatened did not see the posts only because she had intentionally removed herself from that group following an earlier disagreement with defendant. So, she's not the intended recipient. She's not in the group. This is clearly not a situation, furthermore, the post was widely shared on campus. That's not his fault. That's not his fault at all. That is literally negligently overlooking the possibility that someone else would show the person not intended the Snapchat contents. He didn't say like and share this to every student you know. By the way, don't come to school. KK thanks, wink. This is clearly not a situation in which a person shares a private post with a limited number of known associates. It's literally that. Only to discover that one of those associates breached his trust by sharing it further. No, it actually is. Rather, the defendant clearly intended his post to be essentially public. Based on what? There's no evidence that the post was made accidentally or that defendant was unaware of its contents or its audience. The evidence establishes that defendant intended to communicate the contents of the post with any other person, including the people he regarded as snowflakes. This literally just created a fact for the case here. They just decided that exists. To constitute a true threat, a defendant must have made a communication for the purpose of issuing a threat, a true threat, or with knowledge that the communication will be viewed as a threat rather than merely recklessly. So again, for the purpose of issuing a threat or for the purpose and knowledge that the communication will be viewed as a threat. Defendant appears to tacitly concede that his post was antisocial and ill-conceived, but argues that it was merely a reference to his expectation that bringing his gun to campus would cause the minds of snowflakes to melt. As the circuit court observed, a jury could choose to believe that argument, and nothing in this opinion should be taken as foreclosing defendant from making such an argument at trial. However, at the preliminary examination stages of proceedings, the question is whether it is impossible for a statement to constitute a true threat, not whether it is possible for the trier of fact to deem it not a true threat. We conclude that the lower courts both properly found the matter to be a question for the jury. Absolutely disgusting. Absolutely disgusting. The meaning of a particular speech must be considered in its context. This may require consideration of current events and popular culture. Defendant argues that bringing guns to campus was not noteworthy. It is therefore incongruous that he would expect bringing a gun to campus to even raise an eyebrow, let alone melt the brains of people of a particular political orientation. Defendant also notes that guns are often brought to campus for activities connected to hunting, sport shooting, outdoor firing ranges, and more. However, in addition to considering the wider social context, affixing a bayonet drastically changes the apparent context. Bayonets are fundamentally used for hand-to-hand combat. The bayonet affixed to defendant's gun therefore implies that its intended use is against humans, not game animals or paper targets. Are you fucking kidding me? The metaphor of making the snowflakes melt is more consistent with placing snowflakes in fear or possibly even killing them than with causing offense? Wait, what? Especially if bringing guns to campus was otherwise not extraordinary. Conversely, school and other mass shootings currently receive significant media attention. Consequently, social media posts referencing guns, schools, and intentionally obfuscated references to any kind of implied ensuing harm will necessarily be considered in light of that media attention. We note that both students who testified, including the student who did not feel threatened, indicated a belief that other students on campus might feel targeted or intimidated by the post. The other students' beliefs don't matter. They don't matter. That's the amazing thing. They don't matter. It's entirely the intent of Lucas that matters. The intent or the knowledge. When all of the above concerns are considered together and in context, there was ample basis for the district court to find probable cause that defendant knew at the time he made his Snapchat post that recipients who fell into the category of persons he considered snowflakes would receive and feel threatened by the post. Except those recipients weren't intended recipients. They acknowledge it, but then they gloss that later on. To the extent defendant argues that it's unconstitutional, we disagree, blah, 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 blah. Here we go. Defendant does not specifically challenge whether he threatened an act of terrorism as defined, but rather only whether his speech constituted a true threat for First Amendment purposes. This court's grant of leave to appeal was limited to the issues raised in defendant's application for leave, which likewise addressed his First Amendment challenge, but did not specifically challenge whether the elements were sufficiently established. We therefore limit our analysis to defendant's First Amendment challenge. So I guess they could have raised that this was not an act of terrorism defined in the statute. Maybe they should have. I don't think it's going to matter. You've got these three judges concurring on this ludicrous examination of the statement. And so, I mean, to me, they were going to come to this conclusion either way. Absolutely ridiculous. So now this will go to jury trial. This will go to a jury trial. I'm at a loss for words. I don't even know my safe words anymore. RZEQDW says, went on an ambiguous but promising proto date tonight. Got her Instagram at one point. Check it when I get home. Find a picture of her ex. He looks exactly like me. Good sign. She has a type, I guess. Maybe. Hopefully he didn't have like a 15-inch wiener. Trayona says, it's official. Unless you do. It's official. Judges are not reasonable people and therefore should not have any input on the reasonable person standard. What the hell? Dude. Terrible. Lucas Gerhard's appeal. 1, learn how to take a joke. 2, resentment is unwarranted. 3, you wear your grudge on your sleeve poorly. 4, your contempt and malice to people with morals and values is appalling. I think you're saying that to the judges, maybe? I don't know. This can't be brought to the Supreme Court, or is it not worth it? I mean, trying to bring it to the Supreme Court increases the amount. Like, I don't know that they can, I don't think they can take an interlocutory appeal on this issue up to the Supreme Court. I don't know. Adam D says, thanks again for covering this case, Nick. We are reviewing our legislative options, and you will be hearing about it soon. Good. Man, it's legislators need to stand up. Too bad they have Whitmer as governor. Too bad they have Whitmer as governor. But yeah, legislators should stand up for it. People of Michigan should stand up. We'll see what happens. We'll see what happens. For in the meanwhile, prayers to Lucas and his family. I found out I may be able to have a non-computer related contact with Lucas at some point. So I might try and do that. Just give him some encouragement. Tell him there's a bunch of people on his side, and to keep, to hang in there. It's, what else do you do? You've got the sword of the government hanging over your head for 2 years. I hear that Newsom is getting recalled. I mean, I heard they had the petition thing. I don't know. We'll see how it goes. Oh, yeah. Let's, I'll pull up Lucas's GoFundMe real quick. If anyone feels, I know many of you have contributed to this GoFundMe already. If you feel compelled to contribute any more, they can use all the help they can get. This is an expensive case. That's the hard part on this. That's the hard part on this stuff is it's massively expensive. It's like, oh, well, he can just take it to trial. Oh, okay. That's $50,000 or whatever to have a jury trial. Maybe more, maybe less. I don't know. They've raised $76,033 so far, which is phenomenal. They got a bunch of support in there. If anybody feels like donating, here it is. It's GoFundMe.com, Justice for Lucas. I'll throw the link in the chat. SP Curious, remind me on Twitter, like send me a DM on Twitter and I'll get you an article on it. I know there's a couple publications that have run articles on it. So there's that. Whew. What a frustrating case. I'm literally shaking. That's your free speech rights, guys. That's how the government views them. As in, they don't view them at all. And the people who are supposed to be the protector of it, the courts, nothing. Let's see. What's next? Preston Poulter. And let's see how they're doing. On a completely different note, I have a completely different GoFundMe to show you. I am not encouraging the donation to this GoFundMe. I'm merely pointing out its existence. I'm merely pointing out its existence, okay? This is Preston's GoFundMe. Preston's for Stop Hate Stop Comicsgate. You gotta stop. Stop it now. They have raised $240 of $1,000. They've got 4 donations. Very, very cool. I'm very proud of them. They've got Ethan Van Sciver, his one of his tweets in the background there. Replying to, see, but this is him replying to Thomas Royloop. Thomas Royloop is not in this case. He says, "Oh, it's you, the fucking gas chamber chimp. Fuck off, pedo. I just want to read this conversation about CGC." That's not Preston. That's someone else. My name is Preston Poulter, and I create comics books under the label Pocket Jacks Comics. I became aware of the activities of a group of indie comic creators led by Ethan Van Sciver, who routinely ask their fans to harass their critics and competitors under the label Comicsgate. I monitored their activities on my YouTube channel for the last 2 years or so, as well as the increasing intensity of their attacks on me. I filed a trademark for the name Comicsgate when I noticed it was becoming a cult for small-minded people to hate and attempt to destroy others. In response, Ethan Van Sciver called me a child pornographer. I decided something had to be done, so I filed a suit for defamation against Mr. Van Sciver and company. This GoFundMe exists specifically for the legal action against Ethan and his toxic mob. Yeah, Ethan! Answer for your crimes, pie boy! I knew you'd show up when I invoked your name several times, Ethan. Can you imagine being Preston? Oh, how embarrassing your life is. So there we go. And again, his hallmark, he's got Ethan in the thumbnail here. His hallmark is a comment to someone else. And Thomas Royloop is a weirdo, a colossal weirdo. Very strange man. So anyway. Let me make sure there's nothing going on in this case. Nothing after this. Let's see. Find parties. Poulter. Restone. Oh, I gotta make sure and favorite that. Peggy gets pegged. That's what I've named the case. Pacer, when you save cases in Pacer, they allow you to name the cases. So this is named Peggy Gets Pegged. Whoops. Let's see. So the amended complaint. Oh, wait, they got a new attorney now? Wait, okay. So they fired their attorney, but they've got a new attorney. They've got a new attorney. The new attorney is Mohammed S. Ahmed from the Ahmed firm. Let's check him out. I gotta find out who this guy is. If I type in Mohammed Ahmed, I'm definitely going on a list. Lawyer, Dallas. Let's see. Oh, there we go. The Ahmed firm. Here we go. Pull this up. Get this bad boy on the screen. This is the Ahmed firm. Lawyers you can trust. Let's see. So, a boutique law firm. Quality and efficiency you can trust. They've got a stock photo of Dallas. I don't know if this is from their office or if this is just a random place. Let's see what is a boutique law firm? Specializing in only specific areas of law and focusing close attention to the exact legal needs of their client. Let's see what their Samir is very knowledgeable attorney and provides quality representation while making a connection with clients. I highly recommend him. This is Samir Ahmed. That's not Mohammed Ahmed. This is a different guy? Business planning, business counsel, commercial litigation, wills and trusts, hail damage claims. Is this the same? No, it's a different Ahmed law firm. What? No, it's the same one. Sorry. Wait, okay, so his name is Mohammed S. Ahmed. The S must be Samir. My bad. He goes by Samir, but his legal name is Mohammed S. Ahmed. Got it. There we go. So he hired a boutique law firm that hyper focuses on these issues. So business planning, business counsel, commercial litigation, wills and trusts, hail damage claims. Okay. Can we watch the video? Looks like a nice guy. Take a peek. Let's take a peek. 40 seconds. Oh my God! Oh, my ears. Better. Yeah! This is a sick beat. Gonna get a copyright claim on this one. Litigate. Yeah! The instant fade out. The video didn't do anything other than this same thing that it was already here. Okay. I wanted it to come in with some better sound effects and stuff. Oh. God, I wish I had a cool beat for my firm. Oh, gee. I gotta talk to My Room Records. I need a drum machine, just a steady bass kick with like a little glockenspiel playing. Oh my God. All right. So we've got the motion to withdraw the attorneys on record. Well, this is old news now that he's got a new lawyer. The Fine law firm requests permission to withdraw. Good cause exists for counsel's withdrawal from representation. The clients ask that counsel no longer represent them and withdraw as attorneys of record. So they fired him. So they've got all the reasons. This time, no succeeding attorney has been identified. They may elect to proceed pro se, but of course, now we have Samir Ahmed. He's going to take over. Plaintiff's full contact information will be provided. And Exhibit A is a sealed document. Since the information is confidential and because the personal safety concerns of the plaintiffs, counsel believes that withdrawal is necessary because the clients and the attorneys have differences with respect to how to proceed with the case. The attorney's probably like, buddy, you've got a jurisdictional problem here, a massive jurisdictional problem. And the clients have expressed a desire to manage the case in a different manner. Further, the clients have agreed to the withdrawal as signified with their signatures below. Case is still in its infancy, should not prejudice either client or defendant. So there you go. Very simple, straightforward. They signed it. Preston and John Lamont have signed it. This is a great case. This is a great case. I fully support them literally lighting money on fire. The only downside is that the defendants have to also similarly light money on fire. And I think that's a damn shame. I don't think that defendants should be subjected to this. Now, I have heard a lot of people express a severe amount of dissatisfaction with two of the defendants, DAtalks and vickie. Basically, how do I summarize the response I've seen to DAtalks and vickie? I'll summarize it this way. The overwhelming consensus of people I've talked about this case with have said DAtalks and vickie get what they fucking deserve. That being said, no one really has said that Ethan Van Sciver deserves this at all. I don't think any of them do, but I get the sentiment. People have made some accusations about DAtalks and vickie. I'm not familiar with like the details. I don't really care. I'm not interested in their drama. Not my thing. Really not. So if people hate them, great. Have fun hating them. I don't care. But that being said, no one here has suggested to me that Ethan Van Sciver deserves any of this. And again, I tend to agree. I don't see what he would do to merit this lawsuit going against him. At the end of the day, the big problem for Preston and John Lamont is that they're selling a comic book that has an underage character involved in provocative situations with a demon that looks underage that is literally named Lolita. So when you take that, and that, I must remind people, is the advertisement they put out. That's not me looking at that going, okay, I'm going to infer this stuff. That's on the Kickstarter page that they made, or the GoFundMe, whichever one they did, the Indiegogo. That was what they chose to write down. 17-year-old protagonist, demon named Lolita. My inference, or my personal perspective, is that the demon looks very young. I guess you could disagree, although I think the name Lolita is meant to imply it's young, but whatever. So when people say, kinda looks like they're selling Lolicon, and that kind of seems pedophilic to me, well, that's a big problem. That opinion is based on the fact of what you chose to advertise. What they could have done, simple steps to avoid this issue. The protagonist could be 18 instead of 17. Boom. One problem eliminated. The demon could be named not Lolita. Any other name on the entire planet. On the entire planet. They could have picked any name other than Lolita. Only any other name. Done. Those two changes. Those two changes. And suddenly it doesn't look like you're selling lolicon. It doesn't look like you're trying to sell a sexualized story about a minor with nudie pictures. That's it. That's all you had to do. They could have named her pedo lolly slut and it would have been different, better than Lolita. Yes. No, literally, yes. Actually, yes. 100%. That would have looked much more like a satire. Joshua Dunbar says, or we could just get rid of bad laws that criminalize fictional content. This isn't criminal. No one said it was criminal. I don't think it's criminalized at all. I don't think it's a criminal thing. People are just off-put by it and express their opinions on why they were off-put by it. Preston is suing them. No one said it's what they did is illegal. It was just unwise. And their GoFundMe, by the way, or their Indiegogo, it raised $24. I think maybe there's a reason for it. Kidda says, actually it is. The Amber Alert law criminalizes it. It doesn't. It doesn't. And there's going to be, at some point, a First Amendment showdown over whether or not fictionalized lolly content is illegal or not. Whether a drawn image of a identifiable but fictional character is who is underage is actually illegal. At some point, there will be a First Amendment case, but we really haven't had one because there hasn't been a competent challenge to it. Because everybody charged with this right now that's gone to the appeals court, because I did a review of this and looked for instances where this has happened. But everybody who's currently been convicted of this and gone to appeal has also had child pornography of the real kind in addition to these other charges. So usually you've got that when you get to the appeals level. At the district court level, people are pleading guilty without challenging it for whatever reason they're choosing to plead guilty. So I don't buy the fact that it's actually illegal to make underage fictional characters. Like if someone were to draw Lisa Simpson pornography, I don't believe the U.S. law covers it. I know that it says that digital representations or whatever, that law was intended for literally digital imagery when it was written. It was written to cover a digital photograph, because one of the potential arguments is saying that's not child pornography. That's just literally bits on a disc. And until you actually pull up or print out those bits, which you can't prove that my client has done, then we don't actually have the child pornographic picture. We just have data, and that data is meaningless. That's what those laws were meant to sort of head off. So that being said, I don't subscribe to the idea that it is definitely illegal, and I think we'll have a First Amendment showdown on it at some point. But right now, people are not getting prosecuted for this stuff unless they have other pictures, because prosecutors aren't really sure they can win the case. Yeah, parole violations for drawings are different. Parole violations when you're charged with having child pornography, one of your parole conditions is often no possession of any sexual material at all, even whether it's fictional or not. And so those are different. Parole violations aren't the same standard as regular criminal activity, and they're not bound by statutes in the same way. Kidda says, did you hear about Mr. Double in Texas just got sentenced for 40 years for lolly erotica, not even drawings? Well, what if they're not drawings, what are they? Let me see. Let's see if we can find it. Mr. Double, Texas. Here we go. Thank you. Okay. We'll pull up this news story and check it out live. Whoops. No. Hold on. Making me turn off my ad block for this page. Let's take a look. This stream is getting demonetized now. Texas man convicted of running child sex abuse subscription website, feds say. Texas man was convicted of running a website with writings about sexual abuse of children, authorities say. Thomas Arthur, 64, was found guilty during a 3-day trial into content on his subscription website, Mr. Double, according to U.S. Attorney for the Western District of Texas. He's convicted of trafficking in obscene visual representations and text stories about child sex abuse and engaging in the business of selling obscene matters involving the sexual abuse of children. November 2019, the FBI executed a search warrant Arthur's property in a desolate area of South Texas near Big Bend. The raid on the remote compound shook the community near Terlingua. A lot of people think that because this is isolated, it's a good place to just get away from it all, a neighbor told the news outlet. But there's a lot of unsavory characters that know that as well. Arthur opened the website from the property, published writings that included rape, torture, and murder of infants and toddlers. It launched in 1996 and 2 years later began charging members for access to what it claimed were 25,000 stories by over 2,200 authors, according to court documents. Users could access for free or a reduced price if they submitted content, the documents say. Arthur publishes almost all the stories he receives from his subscribers. An FBI agent wrote in a 2019 court document, the only circumstance under which he would not publish a story would be if the content of the story did not relate to child erotica, the story did not make sense, or the story contained too many grammatical or punctuation errors. The website was his only source of income for more than 2 decades. FBI shut down the website when agents executed the search warrant. Investigators obtained evidence from a server where the site was hosted in the Netherlands, authorities say. So this sounds like a Fed case. So let's see if we can find it. Let's see if we can find it. Party search. We've got Arthur, Thomas. There'll be a lot of those. Fuck. See. Texas Western District Court. Is that the one we want? Check. It says he was convicted, right? Here it is. Here it is. His sentencing is reset for June 22nd. Oh, okay, here we go. He was just sentenced 4 days ago. Imprisonment for 240 months, 3 years supervised release. Imprisonment to run consecutive to count 2. Count 2 Imprisonment for 60 months. So he's up to 300 months. So that's a long time. So let's see. Count 3. Imprisonment for 60 months to run consecutive to count 2. Oh, he's up to 360 months. That's 30 years. 60 months. I think you said 40 years or something. Okay, so let's see what we've got here. Complaint. Six pages. Let's see the criminal complaint. Let's get the details. Well, let me read these real quick. Generalissimo says, don't try and choose between the balls or no balls. That's impossible. Instead, only try to realize the truth. What truth? There is no futa. Then you'll see it's not chat that bends, only yourself. Nix Hex says, even John Benet Ramsey. I don't know what that's in response to, but yes. Whatever. Oh, as the name for the Lolita. Okay. Here we go. Jeremy Ewan. No, they won't publicize images in the filings, like on these things, Kidda. They won't do it. Thank God. Jeremy Ewan, a special agent with the FBI, being duly sworn, hereby depose and state as follows. I'm special agent of the FBI. Have served as an SA for the FBI since March 2018. I'm currently assigned to the FBI resident agency in Alpine, Texas, where I'm responsible for conducting investigations of federal criminal violations. I have training and experience in the investigation of human trafficking and child pornography. I also have a Bachelor of Science degree in accounting and have extensive experience investigating frauds and other white-collar crimes. Prior to working for the FBI, I was sworn police officer in the state of Montana for 11 years, included 5 years in the Montana Department of Justice, where I investigated a variety of felony crimes, including homicides. Currently assigned to the investigation of Thomas Arthur. Specifically, he is accused of beginning at a date unknown, but at least January 2005 and continuing to on or about November 7th, 2019, in the Western District of Texas and elsewhere, has been the owner and operator of a website referred to herein as Website A, that traffics text stories about the sexual abuse of children. On the homepage of Website A, it states that it is a text-only site, no pictures. The site charges subscribers a fee to access what it claims are more than 25,000 stories by more than 2,200 authors. The site lists a copyright on the bottom of its homepage indicating that it has been active since 1996. Most of the stories on the site graphically describe instances of rape, incest, and adults sexually abusing children. Regular subscriptions are advertised at $10 a month, $25 for 3 months, $50 for 6 months, or $90 for the whole year. Subscribers are required to provide an email address and a method of payment when registering for an account. The site offers free or reduced price subscriptions for users who submit stories. Authors are required to submit a minimum number of stories and wait at least 1 month before they are granted complimentary access. The instructions state that an author must submit $25,000 for complimentary access. From the context of the statement and length of the most stories, I believe the instructions refer to 25,000 words of content. Instructions posted on the site inform authors that they should write the stories under a pen name and that for privacy, they should choose a pen name that does not match any other online profiles they use. The site instructs, the site instructs authors that all genres of erotic stories are permitted. It also instructs writers to put abbreviated codes with the title of their stories for readers, so readers can search for topics that interest them, e.g. INC for incest or PED for pedophile. Urge to wall rising. Urge to wall rising between September 24th and October 24th of 2019. In an undercover capacity, FBI agents access Website A using the credentials of a paid subscriber who gave the FBI permission to use his credentials. On October 24th, 2019, I downloaded 5 stories from the Website A. Copies of those stories were attached as sealed exhibits 1 to 5 to the search warrant authorized by Honorable District Judge David Counts, hereby incorporated by reference. While downloading stories to attached as exhibits, I observed that subscribers are able to browse the website's most popular stories of the past day. I browsed those stories and observed that they all involved the sexual abuse of a child. Although the stories on website A are accompanied by disclaimers stating they are fictional, they are frequently written in the first person and depict acts of child sex abuse that are within the realm of possibility. One author described traveling to various public beaches and abducting children. Others wrote about child sex abuse by parents, teachers, and other figures of authority. Although website A features numerous disclaimers indicating that all the stories are fictional, a significant percentage of the subscribers I have identified so far have prior convictions for sex crimes against children. Imagine my shock. Who'd have fucking thought? Weird. Oh my God, my mind is blown by this revelation that you would have convicted sex offenders engaging in this. Thus far, I've positively identified approximately 19 website A subscribers through a combination of bank records and FBI databases. Of those, this is a Kiwi. You know he is. He's out here doxing pedos. Of those, 9 were registered sex offenders for either child sex abuse, child pornography, or both. Another is currently awaiting trial in a Utah state court for possessing child pornography and sexually abusing a child. Another was identified as a suspect in a 2007 FBI investigation into an online child pornography ring. I identified 9 instances between 2004 and 2018 where the FBI was investigating a subject for child pornography and found that the subject accessed website A. 8 of the subjects were eventually convicted of child pornography offenses, and the 9th committed suicide after indictment. I'm not sure anything of value was lost. Website A authors publish stories under usernames. A review of those usernames showed that many of them were the same as or similar to usernames that appeared in unrelated FBI investigations into child pornography and child sex abuse on other internet forums or peer-to-peer networks. From my training and experience, I know that it is common for traders of child pornography to use the same or similar usernames across a variety of online platforms. Because they're so eager to abuse children that they can't think of a different name. It's insane. Each author on website A has his or her own author page. On one author page, I observed a drawing of what appeared to be a naked prepubescent female masturbating. The drawing depicted the child's breasts and genitals in graphic detail. Next to the drawing, the author wrote, "Welcome to my webpage. I specialize in stories about little girls having sex." The National Center for Missing and Exploited Children operates a cyber tip line. The cyber tip line collects reports from internet service providers and the general public about the sexual exploitation of children on the internet. I contacted NCEMC and was advised that the cyber tip line has received more than 40 reports involving website A since 2000. On October 23rd, 2019, in an undercover capacity, I accessed website A as a prospective user on the publicly available page and observed a link to submit questions about account access. I submitted a question and received an emailed response later that day. The email originated from Thomas Arthur's IP address at his home in Alpine, Texas. In 2008, law enforcement conducted a forensic analysis on the electronic devices of a website A author. The analysis revealed multiple email communications in 2005 and 2006 between that author and a person using the same email address that responded to my question on October 23rd. There are multiple facts that demonstrate that Thomas Arthur was using the website A email address during the exchange of emails in 2005-2006. For example, all the emails from website A host email address account are signed Tom. Additionally, an email on January 27, 2005 from Tom stated, "I am married. I'm about to turn 50 next year, and I've been married now for some 18 months. Thomas Arthur was born in May 1956, which would mean he turned 50 in May 2006. Additionally, as noted above, Thomas and Sandra Arthur appeared to be married, although no official records are known. It is unclear when they began holding themselves out to the public as married. Finally, in a January 8th, 2005 email, Tom stated, "I still live in this 35-year-old, 850-square-foot house sitting on $100 per acre land. Tax assessor records records for Thomas Arthur's residence in Alpine show the house has 800 square feet. It does not list a year built. Records from the Texas Workforce Commission and the Arthur's Financial Institution showed that both Thomas Arthur and his wife claimed to be self-employed computer consultants. I reviewed accounts from two different banks and did not observe paychecks deposited at either institution, nor did I see payments for what appeared to be computer consulting work. Thomas Arthur deposited checks and money orders totaling between $600 and $1,500 per month between 2016 and 2019. Thomas also received substantial transfers from an account that received deposits from a company that processed credit and debit card transactions. Thomas and Arthur received between $10,000 and $13,000 each month in card sales in 2018 and 2019. 10 to 13 grand a month. Not good enough. Need whiskey. By the way, we're still a bit away from 1,000 likes. I don't care if you like this stream or not. This stream just got real horrible. Real fucking horrible. November 7th, 2019, agents with the FBI, Texas Department of Public Safety, and Homeland Security executed a search warrant on the property. On November 7th, FBI Special Agent Clay Trant and Texas Department of Public Safety Trooper Derek Pearson attempted to interview Thomas Arthur. Arthur initially declined to speak with agents, but later reinitiated contact. Arthur agreed to speak with Trant and Pearson after being advised of his Miranda warnings. Arthur told agents that he operates the websites Website A and slutgirlsforyou.com. These websites are his sole source of income. He does not have any employees and operates the websites himself. He stated he has over 800 subscribers to Website A, and each subscriber is charged approximately $20 for a subscription. Website A has subscribers in foreign countries, and Arthur also publishes stories on Website A in foreign languages. Subscribers submit stories electronically to Website A for publication. Arthur publishes almost all of the stories he receives from his subscribers. The only circumstances under which he would not publish a story received from Website A, from a Website A subscriber, would be if the content of the story did not relate to erotica, the story did not make sense, or the story contained too many grammatical or punctuation errors. Most of the stories he receives relate to child erotica. He acknowledged that the subscribers to Website A may have drawings on their author pages depicting children engaged in sexual acts, but he claimed the images were art. Therefore, I believe there is probable cause that Thomas Arthur, by operating Website A, has trafficked obscene stories about the sexual abuse of children in violation of 18 U.S.C. 1462. Let's check it out. 18 U.S.C. 1462. Importation or transportation of obscene matters. Whoever brings into the United States or any place subject to the jurisdiction thereof or knowingly uses any express company or other common carrier or interactive computer service for the carriage in interstate or foreign commerce, any obscene, lewd, lascivious, or filthy book, pamphlet, picture, motion picture, film, paper, letter, writing, print, or other matter of indecent character, or any obscene, lewd, lascivious, or filthy phonograph recording, electrical transcription, or other article or thing capable of producing sound, or any drug, medicine, article, or other thing adapted to or intended for producing abortion, or for any indecent or immoral use, or any written or printed card, letter, circular, book, pamphlet, advertisement, or notice of any kind giving information directly or indirectly, where, how, or by, of whom, or by what means of such mentioned articles, matters of things may be obtained or made, or whoever knowingly takes or receives from such express company or other common carrier or interactive computer service any matter or thing in the carriage of importation of which is herein made illegal. So yeah, this is actually this is illegal. So there you go. It's not the drawings. It's the stories. The stories are obscene. Yeah, obscenity used to cover way more things than just porn. Obscenity doesn't cover porn. Porn is protected speech. Most porn is protected speech. You think, Kidda, you think this is due for an unconstitutional ruling any day now? I don't know about that, man. You're going to have a hard time convincing the Supreme Court justices that graphic stories about the rape of children are not obscene. They fall under the court's definition of obscenity almost. I mean, I don't know what is obscene if that is not obscene. I don't think the court's due to overturn obscenity anytime soon. I don't think so. I see no indication that the current court especially is going to overturn obscenity laws. Anye Nacho, I should have understood what difference by now. You're stupid. Porn is not protected speech. It is protected under expression and artistic freedom. Yeah, that's under the generalization of speech. Yes, you're right. I guess it's not speech. It's an artistic representation, which is what speech encompasses. So sorry I used the colloquial version. I didn't mean to offend your sensibilities. Porn is protected speech. It just is. Pornography is protected speech. You want to be pedantic about it? It's still protected speech. Obscenity laws violate the First Amendment, but everyone also knows that the obscenity laws are used to outlaw stuff we can't deal with in other ways. The obscenity laws don't violate the First Amendment. They actually don't. That's the thing. The courts have held for quite a while that obscenity is not protected by the First Amendment. You may disagree. With that, but I'm telling you what the courts have held. And I don't see any reason that the Supreme Court would say, you know what? We've had this exception to First Amendment protections forever. Let's change it. I don't think that's going to change anytime soon. I don't see why they would. I mean, they might, but I don't see why they would. Let's see. I'll see if I can find the most recent obscenity law or ruling. Supreme Court obscenity. (1973). 73, 74, 73, 66, 73, 61, 68, 89. (69, 77, 73, 59, 74, 72, 73, 87. Here we go. Check out this line. Dissenting opinions. Let's see. The constitutional definition of obscenity is not faithful to the First Amendment. Yeah, it may not be, but it's been there since 87. That was a dissenting opinion from 87. 89. Anything more recent than that? Can I sort by date? What a pain in the fucking dick. Date. Come on. Load the results. 2021. Okay, that's I'm seeing stuff. Let's see. 2019. Let's see. Private nonprofit corporation that operated public access cable channels were not sub-state actors. Okay. Here we go. Prior sexual abuse conviction involving adult victim constituted predicate offense under sentencing provisions. 10-year mandatory minimum. That's not really useful. Let's see. I mean, they've been upholding obscenity with opportunities to overchange it in the past 5 years. I don't think they're going to change it. I don't see what is going to compel this court to suddenly change course on obscenity. Remember, you have a bunch of originalists. On the thing. And guess what? In 1791, there is no way in 1791 when the First Amendment is passed that you're publishing stories about raping children and not getting shot on site. You are getting shot on site. They're not even going to arrest you. They may bring along someone to rape you before you die. It may not be the ultimate right thing. I just don't see it changing. I don't see it changing at all. I think that the court is going to suggest that there's always an exception for patently obscene materials. All right, let's keep going here. Has engaged in the business of selling and transferring obscene material, namely stories about the sexual abuse of children, by website A in violation of 18 U.S.C. 1466. Possessed with intent to distribute a visual depiction, including a drawing that depicts a minor engaged in sexually explicit conduct and is obscene, violation of 18 U.S.C. 1466 AA. That one I'm curious on. So any person who, in circumstances described, knowingly produces, distributes, receives, or possesses with intention to distribute a visual depiction of any kind, including a drawing, cartoon, sculpture, or painting that depicts a minor engaged in sexually explicit conduct and is obscene, or depicts an image that is or appears to be of a minor in graphic bestiality, sadistic or masochistic abuse, or sexual intercourse, including genital, oral, anal, or oral, anal, whether between persons of the same or opposite sex, and lacks serious literary, artistic, political, scientific value, or attempts or conspires to do so. So the question is, do these pictures depict a minor? And what does a minor mean? That's the question for what is protected and what isn't. I think that it means a real minor, a real person. That's what I think. That's what I've seen. I haven't seen the court uphold convictions for drawings of entirely fictional characters. Although this seems to indicate that these are entirely fictional characters. So let's see what else. I contacted Assistant U.S. Attorney Monica Morrison and Austin Berry, who authorized these charges. Conviction for a violation. So there we go. Here's the charge. Bunch of written stories about children. I don't know if criminality is appropriate on that. I think the person should be killed. Let me let's restate this. I don't know if it is appropriate for the government to criminally convict Thomas Allen Arthur, for what he has done. I'm pretty sure he should just be murdered. I don't know if murder's the right term. I think justice should be dealt. I have no sympathy for this guy. Don't care. None. Look, if your thing is writing erotic, a child getting raped is not an erotic story. If you think a child getting raped is an erotic story, find a bridge and jump off it immediately. Do the world a favor. Go away. Be gone from society. If you think that's erotic, end yourself. Please. Get off. Get out. Get out. Nobody wants you around. You are a danger to yourself and to others. Get away. You're like, oh man, I need to get the next story. I'm sorry. I love you as a person. I hope you find Jesus after the bullet goes through. I don't have any time for you. Nope. Sorry. I don't know if the government needs to punish it. I think society should punish it. I think you should punish yourself. I think you should go. You should be gone. I'm like, again, no sympathy for this person. I have none. I have none. There's a whole bunch of people on that mailing list, FBI. Get them. I don't fucking care at all. I've got a whole list of libertarian injustices that need to be rectified long before guy who writes child rape stories goes to jail needs to be fixed. I'm working on weed. I'm much more concerned, like weed and then all other drugs, prostitution, speech in general, like just generally talking. Those things are way higher on my list than guy who writes stories about kids getting raped. Fuck him. Ugh. Libertarians in name only. No, libertarianism is an ideology that starts from zero and says, how far do we go from there? It does not mean that literally everything is free tomorrow. And if you think libertarianism means that everything opens up tomorrow, that's why libertarians will never win, and it's why they're a joke of a party. Libertarianism is a long-term goal. Society has to be moved back to some semblance of morality before libertarianism works. It's why Wealth of Nations accompanies On Moral Sentiments by Adam Smith. They're complementary books. They're not opposing books. And it's why who was it John Adams who said that a free society must be a moral society? There's a reason for all that. There's a reason for that. I consider myself libertarian. At the end of the day, I would love for no speech to ever be prosecuted. Absolutely. Including the most vile, horrible stuff that this guy is writing. At the end of the day. I've got a long way to go before that's the thing I'm fighting over, though. Plenty of other stuff in front of that one. Let's see. What do we got? Let's see if we have any other interesting documents in here. Oh, what are these? This will be interesting. What do we got here? I do not have permission to view this document. Oh, that must have been horrible. That was the defendant's exhibits. Can't look at those because they're sealed. Can we look at the exhibit list? Oh, we can. That'll be good. All right, here we go. This is perfect. Let's see what we're looking at. Just an exhibit list. Nothing explicit here. Don't worry. Dick has also talked about Mr. Double's case on his podcast. Would you call him to the show to talk about it? Sure. I don't know if I can this weekend. Is he recording on If he's recording on Sunday, I might be able to. All right, so we've got screen capture, screen names, screen capture form registration, member services, screen capture stories. Story 1, A Spectacle to Beat All Others by Baby and Pop. Baby and Pop is the screen name that they chose. You can choose to believe what you will about Baby and Pop. Story number 2, Baby Wank by Evil Dad. Okay. All right. Story number 3, Butt Fucking a 10-Year-Old Girl by Steven 7. Story number 4, Replacing My Wife, She Had It Coming by Baby Raper. Story number 5, The Baby Mangler by Lacherna. Got drawing 1, Netman 169. Drawing 2, Girls Suck. Okay. Drawing 3, Load the Mule. List of story names, summary chart. 30 photos from November 7th. Instructions on uploading to Mr. Double. Tax records, letters to accountants. Let's see, what else do we have? LNK files, author's balance report, child raper Allie and her dad. So here's the problem with this. The problem with this is that ultimately, many of the authors on this are actual offenders. That's the problem we have to overcome with this. That's the problem you need to overcome. At the end of the day, these people aren't just writing about it. Maybe the Fed should just take the website over. See, here we go. What else do we have? Jury verdict. Can you imagine the jury? They're sitting around talking. Wait, can we fucking kill him? Can we kill this guy? Can we just kill him? What is interrogatory for count 7? Oh, here we go. This is good. Let's do this. This is great. So here we go. Let's look at the jury verdict form. All right. Useful. Very useful. Dan Platt says, on a related note, another Fed got caught doing child stuff today, but white supremacists are the real threat to the country. No, Feds are terrible. This guy, the Fed who did that, deserves the wall too. Wick Dipper says, was it the importation of the child subject that made the erotica illegal? The importation is the general law, but any use by any electronic means comes out to an interstate commerce issue. All right, here we go. Count 1. We, the jury, find the defendant Thomas Arthurs guilty of the offensive charges. Count 1, 2, 3, 4, 5, 6, and 7. Special interrogatory for count 7. If you find the defendant Thomas guilty of the crime charged in count 7 of the indictment, please list the title of the story and or drawing you find obscene in the following blank page. Wop. Stories. Katrina and Her Daddy by Q. Tracy. A Spectacle to Beat All Others. Baby Wank. Butt fucking a 10-year-old girl. Replacing my wife. She had it coming. The Baby Mangler. Pictures. Bio picture for Netman 169. Girls Suck and Load the Mule. So there you go. I went ahead and just decided that those stories were fucking obscene. That those met the definition of obscenity, which, by the way, the Supreme Court has laid out a definition for obscenity. It is a real thing that exists. Yeah, the jury had to read all this stuff. You know what the jury's saying? Can we dox the people who wrote the stories and kill them too? Are you saying the lawyer that wrote those should now go to jail? What lawyer? Let's see. What else is in here? Motion for acquittal post-verdict. This will be interesting. They didn't go by the titles. If you think that it's the titles, and an attorney didn't write that, the jury wrote that. It's not the titles. The jury had to read those stories and determine that those stories fell into the government description of what obscenity is. Adam K says, whomever wrote those words on that page, those are obscene and therefore they should go to jail. The words on the page aren't obscene. The stories were obscene. The stories behind the words on the page. No, these are jurors. They're not writing them for the sexual gratification of themselves and the audience. That's whatever you think about the definition of obscenities, propriety, and you're welcome to think that it's improper. In lots of ways, I think it's improper. It just is what it is. And the definition of obscenity is material with no literary or artistic value that is solely for the prurient interest of the viewer. You can think that that's an improper definition. I won't disagree with you. I think it's an improper definition. I think it's vague, and I think it's hazy. I don't know what... And ultimately, at the end of the day, removing obscenity laws is probably a good thing. At the end of the day, we're in the morning. We're in the morning time right now. Again, I'm worried about a whole lot more before I get to, I want to protect a guy talking about raping his daughter. Not interested. Not interested in that being my libertarian hill to die on. We'll get that when we've gotten everything else first. Once we've gotten all the other stuff worked out, then we can get to guy writes story about putting his penis in a baby. Porcupine Applesauce is, let's get our gun rights back first law. Yeah, let's remember that they're regulating the Second Amendment literally constantly. They're saying that you can't own any guns in several states and that you need a license to carry a gun. I'm much more concerned with that. Let's see. To the judgment of acquittal. Let's see the reasoning behind his judgment of acquittal. All right, so here we go. Question that confronts the court is whether the challenged material actually constitutes obscenity. Conviction in this case rests solely upon speech, not upon any separately identifiable conduct. While obscene material may be constitutionally forbidden, the question of whether the material is actually obscene is one that can be answered in the final analysis by 5 of the 9 members of the United States Supreme Court. In order to appropriately analyze the matter, the court must separate the charges into 3 categories: text-only obscenity, pictorial obscenity, and the final count, engaging in the business of selling obscene materials. Text-only obscene materials are unique. The government failed to prove that the text-only materials in this case lack constitutional protection. With regard to text-only obscenity, the prosecution for such has a notable history. The first formal test for text-only obscenity arose from an English case, Queen versus Hicklin. In this Victorian antique, the Queen's Court pronounced the following test: whether the tendency of the matter charged as obscenity is to deprave and corrupt those whose minds are open to such immoral influences and into whose hands the publication of this sort may fall. It was not until United States versus Bennett, however, that the United States imported the Hicklin test around the turn of the century. However, no less an esteemed justice than Learned Hand stated his reservation to the prosecution for text-only obscenity. Between 1870 and 1930, the clash between American Puritanism and erotic fiction reached a fever pitch. Challenged works included Tolstoy's The Kreutzer Sonata, James's Tom Jones, Boccaccio's Decameron, Rabelais' Gargantua and Pantagruel, Ovid's Art of Love, Voltaire's La Pucelle, Gautier's Mademoiselle de Maupin. You know what? I'm sorry. They're listing a bunch of authors, and none of their names are Baby Raper. In 1973, the United States Supreme Court modernized obscenity jurisprudence by setting forth the famous 3-pronged Miller test. 1. Whether the average person applying contemporary community standards would find that the work, taken as a whole, appeals to a prurient interest in sex. Whether the average person applying contemporary community standards would find that the work depicts or describes sexual conduct in a patently offensive way, and does the work, judged from an objective standpoint, lack serious artistic, literary, scientific, or political value. There you go. That's the Miller test. That is the test for obscenity. And the jury in this case found that all of the stories, all of them, and all of the pictures, all of them, violated those 3 things. If you think that obscenity laws need to be repealed, again, I'm not going to argue with you. At some point, repealing obscenity laws is probably a good thing. It is the freedom thing. It is the correct position. I'm not shedding a tear for this guy. I don't care. He can have all of the walls. He can have Trump's wall. He can have the walls of his cell. He can have the walls around the jail. I don't care. Don't give a fuck about this person or anybody else who contributes this stuff. And shockingly, what you'll find is that many of these people are offenders. Weirdo. In 2071, when we've solved all the other freedom issues first, then we'll worry about obscenity laws, which only count in really extremely edge and rare cases. Until then, sorry, buddy. Trust me, if it were up to me, the law would be repealed and you'd be dead instead of in prison. You don't understand how obscenity laws apply to things like drawings and writings, but not porn? The difference is the drawings in this case are about injuring children. That's it. Kidda says, yeah, we say that, but then we have Japan, the home of lolly comic magazines and convenience stores. And they don't have the same issues with offenders. No, they don't, but we do. That's that practical thing. That's an interesting aspect of it. For whatever reason, Japan has their set of laws, and they have lolicon in their, in convenience stores. And allegedly, the people buying the lolicon are not child sex offenders. But what we know is the people visiting website A are. We know that the people visiting that a percentage of the people visiting website A are actually child offenders on the registry, literally on the registry. I don't know what else to tell you. That's this is the reality of this site. And this guy got burned by a law passed in 1934. Look again. This is a serious thing, a serious plea, implore, beg to anybody out there who may be watching this, who may see this at some point. If you crave to consume images, drawn or not, literature, fictionalized or not, of sexual acts with minor children, please, for the love of Christ, do one of two things. Find therapy. All of the therapy you can. Isolate yourself. Get yourself away from any kid ever. Turn off your internet. Never go back. Never go back. Never, ever turn on your internet again, and get all of the therapy you can possibly find. And two, if that doesn't work, find a 9mm. That's it. That's it. Don't harm kids. Don't harm kids. Those are your two options. And I'm sorry that you're burdened with that. I don't care. I frankly don't know or care what trauma brought you to that place. And I'm sorry that you've got it. Don't hurt kids. Don't do what happened to you to some other kid. Find therapy or find a bullet. I hate to put it that way. I don't want to advocate self-harm to anybody. I really don't. I'd prefer you get therapy. But literally, get off the internet forever. There's too many dangers for you there. You need to recognize that as a danger for yourself and a danger to the children around you. Get off the internet. Get off of every grid. The only grid you should have is one leading directly to a therapist. Get help. Get help. Get help. Okay, we're going to read the chats now. We're going to wrap up the show. It's gone on too long. It's gone on way too long. Silva Lucas says opinion 3 joined the Clinton campaign. Stop it. Stop it. All right. Mario Carter says the last few years have really highlighted the difference between a legal system and a justice system. I have expected casino boss to come out of the judges' chambers to fortify the slot machines when you hit the jackpot of actual justice being served. Bad Dragonite says, as annoying as the Trump campaign fundraising messages got, apparently people are saying Bernie's campaign is still sending out donation request messages. Yeah. Bernie, it's a problem. Johan says, when asked for comment on Nick Rekieta, Matthew McConaughey said, I heard he's all right. Alt-right. Yeah. Swords Mage says, I live in a small middle of nowhere, Ohio. I own where nothing ever happens, and Trump decided to pick my town out of anywhere. Told his first post-president rally tomorrow. I've never seen a president with my own eyes. Can't wait to see the best one. Oh, man. Let me know how it is. I hope you enjoy it. Bad Dragonites is just a heads up for Nick and chat. The Shadowrun trilogy is free for the next 2 days on GOG. It's an isometric RPG, sort of like old school Fallout, with a setting that's like cyberpunk, but with orcs and shit. Pretty good games. Maybe worth checking out. Zephael says, have you taken the course on bird law? No. Mario Carter says, Nick's law firm is a hobby because it makes no money. Maybe. Enigma the Basement Troll says, it's Bobby Bonilla Day on July 1st, year 11 of 25 to pay off a $5.6 million deferred contract at a rate of $1.19 million per year. The Mets only have 14 years to go. Think we can look at how such a thing works on Thursday. I have no idea what that is. Enigma, you got to email me on that one, man. I really don't follow baseball. Kevin Dorr says, watch the stream from earlier today about Rudy. What BS? The bar's not going after him because he lied or bad practice. It's about Trump. I agree. But unfortunately for Rudy, he did that in the worst state possible. Spigot84 says, have you heard from Ron since the Vic interview? I have not. Not on direct messages. He may have tweeted something on Twitter. I don't know. I think I'm blocked. I just don't check Ron's stuff. Bad Dragonite says, don't listen to him. Nick deleted the super chat. Soulblade says, on June 25th, 2021, let the record show that Nick said, nothing on earth can make me happier than you coming. Guess I'm about to make you very happy, Nicky Poo. Get it, buddy. Gelth Walker, I read that one. Leo Slayer of SJW Weirdo says, I've been suspended off Twitter for 2 years and never went back on since. So fill me in on the Twitter spurging about Vic on your show from the No Lifers. I haven't been following the spurging about Vic. I really haven't. I retweeted one thing. I retweeted Rich Savoya. He was talking about, let's do this really simply. Rich Savoya, who is a literal who from literal nowhere, talking about legal practice, even though he's not a practicing attorney. He talked about something called the best alternative to a negotiated agreement, which is great. It's a real thing in negotiation strategy. The problem Rick has is he is talking about the BATNA with a view of what happened after the negotiations. He decided that the BATNA was competing against the ruling that Judge Chupp gave, but the negotiations at mediation were prior to the ruling. And because he's fucking stupid, Rich Savoyra ignored all of the non-tangible things that Funimation should have considered in their BATNA. Funimation had lots of reasons to go ahead and turn down the Vic settlement. And let me suggest, there's an entire possibility that Funimation was fine with taking no money. Let me just suggest the possibility, because we didn't discuss this very thoroughly on the Vic thing, but it's entirely possible that Funimation was fine with taking $0, but where they drew the line was at taking the tweet down. Rich Savoya assumes that Funimation wanted the money, that was their drawing the line in the sand rather than the tweets. But let me suggest that it's possible that they drew the line on the tweets rather than the money, because Funimation is backed by Sony, and at the end of the day, a $50,000 judgment that they ultimately got, and even the possibility of a $170,000 judgment that they asked for, is not any money to Sony. Sony's a multi-billion-dollar company. $170,000 is basically nothing. $170,000 is a small amount to Funimation, which is a multi-hundred-million-dollar company, without considering the Sony backing. So to have $170,000 in litigation, I mean, sure, they'd want to recover it, but Sony's not really, like, Sony and Funimation might be less concerned with recovering $200,000 of legal fees than they would be in whatever the implications of taking down the tweet are. Rich Savoyra did an incomplete analysis on BATNA because Rich Savoyra has nothing, is nothing other than a fucking idiot. That's the reality at the end of the day. So he accurately described what a BATNA is. He just didn't apply it accurately to this case because he has no idea what's going on, because he's a random nobody with no notable accomplishments in his entire life. I don't know how else to describe it. Try and find him on YouTube or on Google. Try and find Rich Savoyra. See what life accomplishments he has. All you'll find is his Twitter. Not Applicable says, maybe you and Vic should have discussed this. Should have discussed what? No, I don't think so. I think the interview is fine. Tamara Holloway says, uncivil law vid on Cheer case speaks to Lucas's case. It kind of does. It kind of does, except that he's not going to a public school. He's going to a university. Those are different things. Wolvenar says, if he wins, can he sue, i.e. malicious prosecution? No, probably not. Lucas will not prevail in a malicious prosecution case because those do not work. They should, but they don't. Matthew Harder says, hey, Nick, as far as Christianity is concerned, foreskins are okay. But do you as a parent prefer boys to have the chop or not? It's easy to clean. What about having more nerves when they grow up? I don't know that you can confirm in any way that the more nerves is actually like beneficial to the child or hurtful to the child, and because it's going to be subjective, right? Like, unless you're an adult that gets circumcised and you say that I lost feeling due to the circumcision, generally speaking, you're going to only have your perspective. So more nerves doesn't necessarily translate to more thing. I stay out of the debate. Look, it's a thing that people do for either traditional or non-traditional means, and what they choose is what they choose. Some people consider it male genital mutilation. I don't know. I'll speak for me. I'm circumcised and sex is great. I'm circumcised and I enjoy thoroughly putting my penis into a vagina. It's wonderful. That being said, I don't know what an uncircumcised person feels. I don't know if it's different. I don't know if it's better. I don't know anything about it. Sorry. Can't help you there. So as for what decisions people make for their children, you know, I'm not going to judge anybody either way. Genital mutilation is genital mutilation. It's all okay or none is. No, actually, I think genital mutilation of females, as in the context of genital mutilation, is a vastly, vastly different thing. They're talking about removing the clitoris and then literally sewing the vagina shut partially. That's a bit different. And they do it when the kids are 14. Again, a bit different. I'm not going to tell anybody what to do with their children. Other than female genital mutilation is appears to be a wrong thing. It's the same? I don't think so. I really don't think so. But, you know, you can think so. So only the Jewish version is okay? Noted. I didn't say the Jewish version was okay. I didn't say that at all. Realize they can do the similar with penis too, right? Sew the foreskin shut around the penis to prevent him from peeing. Do they do that? Who does that? That's not a thing that I've ever heard of. What are you talking about? Like, Nick is a small hat, confirmed. No, I did not say it's okay. I did not say it's the right thing. I'm not going to comment for or against it. I can only speak to my experience. That's it. It's basically trans surgery. I think that's a little bit different. The degree. Eldon Bainling says circumcision is male genital mutilation. No consent is given. It's based on religion/tradition, just as female genital mutilation. The degree of damage done to the organ is irrelevant. It's the same, Nick. No, I think it's relevant. I mean, if you have a different degree of damage done, that is relevant. It doesn't necessarily mean one's right and one's wrong comparatively. They might both be wrong. I guess in theory they might both be right, but the degree of damage done is definitely relevant to the discussion of whether or not one is different. Clipping your nails is technically damage. Chopping off your finger is technically damage. The degree of damage done is wildly different and very, very relevant. Again, I'm not telling anybody for or against circumcision. It's not my place. It's not my knowledge, expertise. It's not anything. I can only speak to what I know. I can only speak to what I experienced. I can't speak to what other people have experienced or what other people do to their kids. And I'm not going to tell you what I've done to my kids either way. That's just not that's not relevant to this YouTube channel at all. You can decide what to do with your own children based on what's legal. You should do more homework. Yeah, I should fucking do more homework on I'm not going to tell people what to do on what's legal versus what's not because I can't speak to the other experience. No, you should do fucking more homework. Fuck off. Fuck you. Get bent. Fuck yourself. I don't care. Fuck off. Fuck you. I'm sitting here telling you I'm not going to tell people what to do. I'm not going to be the one to decide it because I don't know. You should fucking do more homework. And while you're at it, fucking off yourself. I don't care. Fuck you. Fuck you. Epicurious. Yes. Fuck you. I'm sitting here telling people, don't listen to me on the subject because I don't know. By the way, fuck you. If you want me to tell you in DMs, I'll tell you there too. Fuck you. Fuck you! So fucking tired of you fucking morality pimps come out here try and tell me. I'm telling you, you go figure it out for yourself. And you're like, oh, don't tell people to do that. Fuck you, you fucking piece of shit. Fuck you. Fuck you. Fuck you. How's that? Fuck you. You should do more homework. Do more homework on when someone tells you, I'm not the person to tell you, go figure it out for yourself. You do more homework. Fuck you. Fuck you. You guys brought up the subject. I don't know anything about it. I don't want to know anything about it. I'm not going to tell you about my kids. I told you about me. Told you about me and what I know. I'm not going to sit here and disclose what I did or didn't do to my children to you because that's literally you guys wanting to know about my children's genitalia. And if you want to know, if you haven't figured out from the past hour of this stream about my children, what I'm going to tell you about my kids' penises, fuck you, you fucking pervert. You disgust me. That being said, go figure it out for yourself. I don't care what you do. Go do it. Whatever you're going to do, that's on you. Not on me. It's not my responsibility. I'm not a doctor. I don't want to be a doctor. I don't want to advise people on this subject. I literally don't want anything to do with it. The fact that you guys are obsessed with it, who are, not all of you, I know, but some of you who are obsessed with it, seriously, get fucking help. Weird. Weird shit. Fuck off. Christ almighty. Drew Bradley says, what is a firearm? Has words painted or has a sticker? With notions or even the same as Lucas words. Can it be used against a firearm owner? Thank you. What if a firearm has words painted or has a sticker? Don't put stickers or words on your firearm. Don't do it. Don't do it at all. Legal advice. Do not put words or stickers on your firearm. Guns are tools. They're not for decoration. And if you put some cool, edgy speech on your gun and then you end up shooting someone, you are going to prison. If you write fuck off on your firearm, unless you're a cop in Arizona, if you write fuck off on your firearm and you shoot someone, you're going to prison. Don't do it. Silver Coins Go Clink Clink says, it's hard to believe these tards get extra spur you when told to make their own decisions, but here we are in 2021. It's insane. I don't know. Dr. Crocodile Whisper Dundee, thank you for the donation. Terrence Floyd Fake Tears says, what's up? I'm forgetting to be saying my fellow black supremacists be attacking the U.S. for over a year, and they also be getting the slap on the wrist, G. Thank you. Shankaval says, is it possible for a higher level judge to strike down, smote, reprimand lower level judges' bad ruling enough to actually have an effect on the career? No. Impeachment is the only effect on a judge's career, or on election in some places. Snuggle Struggle says that GoFundMe implies EVS and company are encouraging their viewers to go after others. Every video EVS and company do, they tell their viewers not to contact and or to bother. Of course they don't. Rank Midget says, do you own a small hat? No, surprisingly, I'm not Jewish. Not Jewish. Raised Catholic, now some brand of non-denominational Christian. SM Scorks 89 says, EVS, Vickie, and Dean have not yet been served. Also, Poulter and Lamont have hired Jeremy Maston of the Maston Law Firm as lead counsel. Ahmed is not. That's not according to Pacer. According to Pacer, Ahmed is lead, or Samid is lead counsel. So if they've hired someone else, they haven't filed it yet. Matthew Harder says, hey, Nick, my former tenant is Marvin Guy's brother. People in Texas believe Marvin Guy was the patient zero for no-knock warrants. How much to do a video on him in the case? Texans hate no-knock. Send me the email. Send me the email. Rank Midget says, press X to doubt. Yes, I'm clearly an Anglo Jew who believes in Jesus. The Big Red Bear says the gulag is a solution to this kind of problem. Just send these people to forced labor indefinitely. All of the users, not just the owner, easy. Matthew Harder says, by the way, Nick, Marvin Guy of Killen, Texas, has spent 6+ years in jail without a conviction yet. His family claims he shot in self-defense. Never heard of him. Would be interested in the case. Devil's Advocate says, great stream. Ambulance Chaser Esquire reading criminal complaints against a pedo won't get you demonetized. Oh, yes, it will. 100% it will. Keep grifting Boomer and Cox to mofo Q. Not applicable says, wait, so shouldn't It by Stephen King be illegal? I don't know. I don't know. MLG Magikarp says, hey, Nick, finally going home in a couple hours after 6 months of training for the Air Force. Thank you for streaming to people with sleep problems. My pleasure. Shakaval says, Bubba Pick works not pretty, but it's honest work. I don't know what that means. Matthew Harder says, Nick, if 1776 law said you had to get great because you were a chomo, then Vaush is building a time machine to get the Mr. Hands treatment. Rank Midget says, my calipers on the screen tell a more accurate story than your protestations. What you failed to consider is that my nose is very Polish, not Jewish. I checked. I don't have any Jewish blood. Don't know what to do. Oy vey, give 10% to the temple every time. Every time I celebrate the Jubilee. The Jubilee. I let the slaves go all the time. Oy, I don't know what to do. I love the shekels. Love the shekels all the time, but can't find the Jewish blood. 200 Watt Studio says, how many months you think Arthur lasts in prison? Too many. Too many. Not applicable says, that's a case for letting them so you know who they are. Uncycled says, for the 9mm PSA. Texas Red says, read the Lucas verdict. Read the Lucas verdict. We are doomed. I mean, he hasn't been convicted yet. He has not gone to trial. Has not gone to trial. Herbie Slayer says, authors are unindicted co-conspirators. Elliot Hager says, every time I catch your stream, my disgust finds a new level of Super Saiyan. Persona Non Grata says, Nick has a futa named Jafar. She comes from afar and screams, Allah Akbar. Peace and love to you and your family. Movie suggestion, Escape from New York. We already did it. It was great. Human Crouton says, being circumcised rules. I respect that my genitalia is a contract with God. There you go, Human. Don Gamer Guy says, Nick, do you like your Fudas cut or uncut? No preference. No preference. All Fudas are welcome. Not So Handsome Jack says, so I pass out when you talk about Lucas, then wake up to hear F you, and what the F did I wake back up to? Also, I may have a narcolepsy problem. Also, hi, Nick. Sage Emerald says, if someone actually caused your infants that much pain, I'd hope they'd regret it. People want to disavow the position because of, I think everyone should learn about this, including you too. Learn about what? Learn about what? You have no idea what I've done in either case. You only know about me, which is by design, by the way, because I'm happy to disclose details about myself. I'm relatively an open book. That being said, I'm not going to tell anybody what to do or not do because I can't speak to the other position. It's a logistical impossibility. I don't know what it's like to have a foreskin. And if you have a foreskin, you don't know what it's like to not have one. You can't. The only people who can are people who had one and then now don't. And they may be out there. Maybe they should write a book. I don't know. Go read it. Go read it. You do you. You do you for your fucking kids. Go do you. I'm not telling you what to do or not to do. It's the anti-circumcision people are the weirdest fucking cult on the planet. Jesus Christ. All they want to talk about is baby foreskins. And it's like the same disease that fucking Ginsburg has. I don't get what your obsession is. Back off from it. It's weird. No one wants to talk about it with you because guess what? At the end of the day, you're just a guy on the internet too. Such a weird topic. And the people are like, I hate this topic. I hate it because the people are so fucking vehement on it. They have to let everyone know. They're like, well, I really want you to know about all my knowledge about baby foreskins. Dude, calm the fuck down. We're at a Denny's. Stop. Jesus Christ. It's the weirdest thing on the planet. You have to stop. You have to stop before you end up like Arthur. Again, you go do the research. Go do you. Go decide what you're going to do with your kids on your research. Go. Your religious traditions, your research. Don't talk to me about mine. I don't want to hear it. My kids are, my boys are in double-digit ages. Believe me, at this point in time, they are at double-digit ages. No circumcision is happening to my children at double-digit ages. This is not the fucking Old Testament, okay? So let's just move on from that subject with a hearty fuck you to anyone who keeps wanting to bring it up. It's so weird. You're weird. You're weird as fuck. Seriously. Go to a grocery store and start talking to people about circumcision. I hope you get beat the fuck up. It's weird. It's the weirdest shit on the planet, and you need to know it because no one else has the common goddamn decency to tell you you're being fucking weird. Find a different hobby, man. It's weird. Someone says, find a different topic, Nick. That it's done. Let me read you the next chat. St. Umu says, I have found there can be psychological damage done thanks to circumcision, and any genital mutilation is fucked up. Also need that foreskin for my Fuda. I literally, this is a topic I literally never want to discuss. I don't want to discuss female genital mutilation. I don't want to discuss male genital mutilation. Neither of them are on my radar of topics. I never, ever want to discuss them. I don't want to discuss the genitals of children. Please, for the love of all that is holy in the world, stop bringing up your infatuation with the genitals of children. It's fucking weird. It's weird. Joel Reese, thank you for the donation. Blackhawks 81H says you should see if Beau Lefebvre will come on and talk about the Lucas thing. Super pro Second Amendment state rep from the other end of the Upper Peninsula. Shagaval says the Bubba is in regards to rap before deading baddies. Matthew Harder says, man, Nick, I'm a Christian. I just heard the foreskin argument from atheists talking about nerve endings. I just wanted a parent's take. That is all. Sorry. Matthew, I'm sorry. That is one of the things that is off limits to me. I'm not going to talk about medical decisions or genitals of my children. Like it's just not, it's not my thing. You got to talk to religious and medical advisors on your own thing, on your own time. I'm not here for it, man. Sorry. Eldon Bainling says, stop talking about foreskins and get on Twitch, bruh. St. Umu says, no, Nick, we don't talk about this in public. You are in public. You're in public right now. You're in more public than you've ever been. There's 800 people still watching this show. I've told half the people to fuck off, and there's still 800 people watching. You're in public right now. Problem is, this is abuse. No one is taking it seriously. This is Old Testament stuff, actually. Go talk about it to legislatures. Go make it illegal or whatever. Go do what you're gonna do. You're actually, you are in public, and I am not your guy to take up either position. I'm not pro circumcision. I'm not anti circumcision. I told you I can only speak to my experience. I am circumcised. Love sex. Can't tell you anything else than that. If I was uncircumcised, would I love sex more? Don't know. Can't know. I can't undo it. It's a decision different people made at a different time for me. Am I mad at them about it? No, I don't fucking care. Don't care. There's no basis for me to care. That's the weird thing. Cinema Queen says, you can tell me to fuck off, Nick. I'm still going to watch every night. Yo, fuck off, Cinema Queen. Wick Dipper says, should a foreskin be washed with warm, soapy water? Yes. Ace of Spades says, the real Futa question, with or without foreskin. Oh, stop it. No. Bad Dragonite. We've got some justice chats that have come in. That one guy says, so what should you do if you're a psychopath that thinks we need a society where private people kill their neighbors regularly on accusations of thought crimes? You got a therapy budget about that? Just wondering. Yeah, go get therapy immediately. Emperor Palpatine says, yes, Master Nicholas, your anger makes you powerful, gives you focus. Now give in to the dark side. Okay. Malik Foxton says, how'd circumcision and genital mutilation come up again? It was a super chat. Suddenly Nick's telling the chat to fuck you. No, I'm not telling the chat to fuck you. I'm telling specific people to fuck you. Why do we care if someone's circumcised if the person who is circumcised ultimately doesn't care 99.9% of the time again? Don't know, Malik. Don't know. Don't know why that's such a thing. But, you know, those people need to deal with that on their own, in their own private lives. Bad Dragon Knight says, news, the hashtag MeToo accuser of the Smash YouTuber Zero admitted they were actually 18 plus and asked for the material he sent and that he never contacted any minors. This admission is after a year with Zero's career ended after his attempted suicide. He also says, I think the chat asking about Stephen King's It is referencing a scene in the book where all the main characters have sexual intercourse together in one of the childhood chapters to obtain the power of love, or however it's worded. Yeah, haven't read the book, can't speak to it. Stephen King deserves a wall. Arrow Shogun says, Leave the Jew alone, you filthy goyim. But now that you mentioned that you hate this topic, we're going to bug you about it even more. I found it weird at first, but now I think it's hilarious. Good. Great. I've already set myself up for failure. Matthew Harder says, again, Nick, sorry, man. I'll send that Marvin guy email. It's okay, Matthew. You asked a question, and it happens to be a subject that I really, really hate talking about because I've dealt with the. It's weird. It's not that weird. The pro-circumcision community doesn't seem to have like a strong vocal position on this. The anti-circumcision community has a very, very dedicated and vocal opposition to it. And that's fine. That's great, sort of, except not here. I'm not going to answer your stuff about it. I find it very, very weird. I think it's something that is massively intrusive. And I think the people, unfortunately for them, I think the people who are pro or anti-circumcision, either way, are arguing on half the set of facts and just not really interested in the argument. Never been something I've been interested in. I hate when it comes up in any online discussion because it becomes such a lightning rod and it's so fucking boring to me. CJ says, so how about them Redskins, or is it Foreskins? They should change their name to the Foreskins. Ellen Bainley says, second half of the stream was depressing, Nikki. Lol. Look. Good. Not So Handsome Jack says, so uncircumcised lives and circumcised lives and circumcised lives matter? Yes. All male lives matter. All female lives matter. They really do. They really do. Amateur Ant says, Nick, do women have 4 holes or 3 to use? What's the fourth? Is the fourth only if they're fat? I don't understand. Ryan79 says, knife to cucumber. No one important says, hey, you don't know that. I can always just grow mine back like Piccolo with his arm. Maybe I haven't tried hard enough. Yeah, try harder. Just sit there and look at your penis and go, ugh, and see if you get it back. All right, guys, that's the show for tonight. The Neen says, hey, Nick, did you hear that Kutaro foreskin died? No, Burr's cock is never going to get finished. 200 Watt Studios says, Nick, pro or anti-pineapple pizza? Anti. Pineapple on pizza is degenerate. I hope it dies forever. Thanks, guys, for watching. I hope you have a good night. I took my 1K shot. I've drank too much. I guess we'll go on Twitch and watch a movie tonight. It should be fun. I'll figure something out. Catch you. I did do the 1K shot. I absolutely did. What about strawberries on pizza? Oh, my God. Get on the wall, kidda. What are you talking about? All right, guys. Catch you later. Have a good night. Ryan7979 sent 2 peace signs. I think he's saying peace. Peace. Oh, fucking hell. I got to turn on this.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Rant to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the deposed on Twitter as we hear law-splaining tonight. From the white shores of Rant to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea. Post on Twitter as we hear Lost Painting tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed